I don't know how many.
Okay.
Talk shoes.
Recorded live.
Yeah.
Okay, so you're started, right?
Yeah, I'm started. Okay.
Yeah, so I don't know what the heck's going on with that. I don't know how many of our people even know there's a show tonight. That's the problem, because that's the big list helps us stay in touch when there's when you're on a Thursday instead of a Friday, So, a little disconcerting.
Okay, let me get over to Angela's.
Okay, all right, and I'll just shut up, and then you just mute us out, and then I'll just listen on this end. That's all.
Okay, yeah, just hang on there a minute.
Yeah, and don't ask me about the big list, because I just don't know unless afterwards, you want to talk about it or whatever.
Yeah. Some people. I understand what he wanted, but I'm the wrong one.
Right, all right.
He's got a problem. He needs somebody that's running from the law that's in his house, and he wants me to go get him out. Well, I'm not that type of bounty hunter. I'm the good kind. I go after the real corruption. All right, let me mute everybody. Just hang in there. KAIB radio. All right, I'm going to call into hers. I'm going to do a flash.
Okay.
As soon as they unmute me, then I will be able to come in and talk on her show. So I got both screens up, hers and mine.
Okay, I'm back. Oh.
You are unmuted.
Hello, Angela.
How are you doing?
Oh, good. I just I got my show tied into this, so I've got my program running at the same time.
Fantastic. Yeah, I got the email, but we haven't started yet, so.
That's all right.
Okay,
Wait a minute. Angela, this is Harvey. Did you get a big list about the show tonight?
No. A big
okay.
list? I got an email, but that was yesterday.
Who did you get the email from?
I guess. I thought it was from you, from Rod.
Well, no.
It came from AIB. Well, I'm on the talk show. I'm on the follow this thing.
Oh, okay. So Rod, did you
show.
send out an AIB member list email? You did. Did or you did not?
Yes, I did. I sent out on my talk show. I have a list, and I sent the list out.
Oh, okay. All right. So you did. I didn't get that one myself. Huh. I don't know what's going on. But anyway, Angela, the whole thing is the big list is not really working. There's some problem with it, or we'd have at least 2,000 people on the big list know about tonight's show that with Rod and you. So anyway, sorry, we called.
Okay. Oh, it's okay. I sent it out to my list too, so our list, I should say.
Okay.
So, yeah. I mean, if it gets gridlock, well, we'll deal with it, I guess.
We're all here right now. That's all that matters.
Yeah.
Between you and Rod, and I'm just a kind of a bystander, that's all.
Okay. All right. Well, it's 6 o'clock, so I'm going to get the call started. I'm going to start the recording, and then we'll do the intro, and you can share with us all your experiences, Rod.
Okay.
All right. Let me get this going here. Hold on.
Talk shoes.
Recorded live.
Hi, everybody. It's Thursday. It's May the 21st, and it's time for my private audio call. Tonight, our special guest speaker is someone I've known for many, many years, just via the internet and phone only. I've never met you in person, but tonight our special guest is Rod Class. I know you all know who he is or have heard of him at one point or another. Hi, Rod.
Hi, how you doing?
I'm great, thank you. How are you?
Oh, we're hanging in there. We're still playing with the D.C. court system. They're not answering my paperwork at the appeal level either.
Wow. Well, for those people that don't know who you are, do you want to give us a little rundown of what you've been up to for the last, 15 years?
Yeah. Okay. What I am, I'm like so many of the researchers out here and so many of the people that you have, we're trying to find avenues to correct the court system. No one person or one group has all of the answers, but one thing that I've learned, and the gentleman that taught me back in 2001, when I got into this, and I got stopped on a traffic stop of all things. It was a traffic stop, and I had a valid old license from the state of Florida. Even though I was in Ohio, I was born and raised in Ohio, my Ohio license was transferred. And this is what started me on this whole horror run of what we have done with the court system and what I have found just how corrupt it is. A lot of the people back at that time, back in 2001, they was going after the oath of office, they was going after their bonds, they was going after the fact that, well, I'm not a person on the way you have it spelled. And a lot of what they said is like today. Are they wrong? No, they're not wrong. If the court system was running properly, you got to be able to walk in, ask that judge for his oath of office, and the moment he says he doesn't have one, that automatically disqualified him, dismissed your case, and he walks off the bench, or she walks off the bench. That's how this is supposed to work, because they can't commit a felony whenever they're dragging you in for a misdemeanor and trying to make it a crime. But the gentleman taught me, and my brother, and he sat here and said, no, you have to know three things. You have to know their language, you have to know their job description, and you have to know their rules. And those rules are not just the rules of court, it is the legislative acts that they're supposed to be coming in compliance with, and that which is the statutes at large and the acts of Congress, not necessarily the USC codes, because through the years we found out the USC codes, their language was twisted from the original intent of the act of Congress, and that's why it's called color of law. But during this time period of doing this research, I also asked a gentleman to teach me how to do paperwork. Don't sit here and tell me. Show me how to do the research. Show me how to do the paperwork. Because if anything happened to him, I don't want to be left hanging in a court because I don't know squat. So he took me under his wing, my brother and I, and he taught my brother and I how to do the paperwork, how to do the research, and how to come in, how to walk into the court. And the moment the judge sits here and starts reading off your charges, instead of sitting here saying, well, Your Honor, I apologize, boy, I really shouldn't have been in the state of Ohio with an out-of-state driver's license. You know, I really shouldn't have allowed my Ohio license to get, expired because I transferred it. Instead of making all these excuses, I was never taught to defend myself. I was taught the moment the judge read my charges off, and they asked me, Mr. Class, do you have anything to say? I says, yes. I want to see your oath, and I want to see your bond. I want to see your qualifications to hold this job. Before you talk to me, you got to show me you're qualified. And that's what started this whole thing. And I've watched these people run out of the courtroom. I seen the prosecutor run and the police run. And my brother and I, a couple of people, was the only ones left in the courtroom because we hit them up. And there was the magistrate. Well, I got put before Judge Space. And, of course, Judge Space did the same thing. She read off my charges, and I was very polite. I raised my hand. And she says, yes, Mr. Class. I says, we got a problem here. I says, your boy over here, referring to her police officer, I says, and your prosecutor doesn't have an oath of office. Matter of fact, they're not even bonded. And she says, well, I'm going to say that they are. I says, no. I said, did you bother reading your Ohio statutes under 3.24 that sits here and says that his oath and her oath had to have three signatures on it? It had to have the person who gave their oath. They had to sign their oath. The notary had to sign their oath. And it had to be filed properly with a stamp on it. She crapped. She said, well, we're gonna postpone this, and I want you and the prosecutors to file letters back and forth. So what happened here is the prosecutor came back in. She made the statement that she was a mere assistant to the law director. and that the police officer actually worked for the state and didn't work for the city. Therefore, he did not need a city oath of office. Well, I went down to the city charter. I went down to their codes and regulations for municipality that dealt with the police department. And it sits there and says, if you are a police officer, you have to live within the city, and you had to have an oath of office and a bond. And if you are a county or a municipal prosecutor, then you had to have an oath, and you had to live within the city. Well, when she sat down and said she was a mere assistant to the law director, I went back and looked under the law director. And under the law director, she was right. She did not have to have an oath of office under the law director because she could only operate in mayor's court. That's it. Not the municipal, mayor's. So we went back in and I started quoting their city ordinances, their city codes. I says, okay, she said here, if she is claiming on the record that she's a mere assistant to the law director here under New Philadelphia city regulations, she can only operate in mayor's court. Therefore, she lacks subject matter in the municipal court, because if she worked on a municipal court, these were her qualifications. And if the police officer doesn't work for the city and he is a state officer, then he is now impersonating a local police officer in an improper uniform and in a city patrol car. Therefore, he's now impersonating. Well, when this hit the court, the judge cracked because she ripped up the paperwork. She says, I'm not going to allow you to do this. She says, I'm going to find you guilty. I says, no, you're not. I said, because you and I are going to have a go-round on this. I says, I do have a valid driver's license. I says, and that's the point here. I have a license from the state of Florida, even though I may have lived in Ohio. My license from Florida is 100% legitimate because you've got a compact agreement from state to state. And you have to honor the compact agreement, and you have to honor the Highway Safety Act under Title 23, Section 1250. And 1327. Well, she sit down and postponed the hearing to the following week. Well, when I walked in there with about a foot of paperwork from the federal all the way down to the city. And I started hammering them on their oath, their bond, the compact agreement, the federal funding. And she asked me, she says, Mr. Class, are you a lawyer? I says, nope. She said, well, then you can't use this stuff in your defense. I says, excuse me? She said, that is only for lawyers to use. You can't use it. I says, good. Then you can't charge me under something that you can only charge a lawyer for. Well, she banged the gavel, nailed me for $285. And I looked at her and says, how do you plan on collecting this $285? I says, you can't have my license suspended, because you just now admitted that I don't have one, and what are you going to do? Call Florida and tell them to suspend my Florida license because I dropped her driving with a Florida license? I says, good luck. I walked out. That's what started this whole thing. That's what.
Then what happened? So then what happened? You just walked out, and that was it? Or?
I just walked out. I didn't pay no fine because she could not enforce her ruling because she had to notify Florida to suspend my driver's license for failure to pay a fine. And she would have to tell Florida that their license was no good in the state of Ohio. She couldn't do that. You follow me what we're saying here?
Yeah. Have you ever known a judge or to have an oath of office?
No, she didn't. Matter of fact, we had her up on hers because her husband, which was a city law director for the next town over, gave her oath of office, and we hit her up on this, and she came unglued. I says, your husband can't give you an oath of office as a city law director whenever you are a judge in this town for the county. That's a conflict of interest. Well, she just come all unglued. She started yelling and screaming at me, but that's what started me on all this. Wow. And throughout the years, I got learning more and more and more, and I started doing more research into the congressional side, into their statutory side. Because what I was running into, Angela, is a lot of these people, they came back in and they said, Rod, you need to argue that you're not that all capital name. You're not that person, because it's all caps. That's a corporation. I said, okay. I want you to tell me where it says that all capital name is a corporation. If I'm going to make this argument, I want to be able to walk in here, because I was able to walk in with all the different laws that says they had to have an oath, they had to have a bond. I had all the laws that shows that how they had to comply with a compact agreement from state to state. So if I'm going to walk in and I am going to tell this judge that I am not that person on that sheet of paper, that that's a corporation, I want to know where it says it. And the problem is, Angela, what I ran into is like so much of this stuff out here when it comes time, well, I got this off this guy down the street, or I got this off this other guy. I said, that is not good enough. I want to know where it says my name is a corporation. Don't tell me you got off somebody. Tell me where it's at. So throughout the years, I started researching. And I was on another show back in 2005. At that particular time, I was teaching impeachments. And we was getting into how to impeach. And I ran into another traffic issue down in Florida. I went up before the judge down there. I walked in, and the judge sat there and says, Mr. Class, I'm the judge here, and I'm going to start asking you questions. I says, well, I object. She says, what do you mean? I says, you cannot ask me questions. Where's the prosecutor? Who's representing the state in here? She says, I am. I says, no, you can't represent the state. You can't ask me questions and make rulings on your own decision on this. So she called up the police officer, and the police officer started explaining that I was involved in an accident, and my brakes went out on my truck. I ended up rear-ending an old couple. And so I started talking to the police officer. I started asking him. I said, I want to ask you a question here. Do you represent the state in here? He says, no. I said, did you bring a complaint against me? He said, no. I said, wait a minute. Who brought the complaint? Well, the state. I said, who represents the state? The judge says, I do. I said, no. You can't represent the state. You can't be prosecuting and represent the state and be judge. That is a violation of separation of powers here. Well, I got into the definition of the word person with this cop because I found, through research, I found what it meant and what the phrasing was. So I started explaining to the police officer what a person was. And it was a federal citizen. It was an alien back at that time. It was not me, not by legal definition. And I started pulling out the books, and I started showing him. Well, I happened to have 2 FBI agents with me at the time because they knew who I was. They wanted to go into court with me. They wanted to see how I operated. Because they heard about me. They knew who I was. Well, as I was sitting here making this issue, you can see the State Highway Patrol and the local sheriff department and the police officers that was sitting there waiting to have their case heard. They started getting very fidgety. They started getting very nervous because I started laying out procedural violations. I started laying out how they did not have an injured party. They didn't have a corpus delicti. They didn't have anybody that filed a complaint. Well, the old couple come up, and I asked them, I said, did my insurance company fix your automobile? They said, yes. Did my insurance company take care of any hospitalization? They said, yes. I said, do you have any complaints about my insurance company? She says, none at all. I said, did you bring a complaint against me? She says, Mr. Klaus, we didn't bring no complaint against you. I looked at this judge. I said, then who in the hell brought a complaint? Well, the state. I said, the state is not in here. Where is the state and how was the state injured? And I started jumping all over this judge on this thing. Well, she banged the gavel, nailed me for a $275 fine, and I had to pay it because I was in Florida and I didn't want my license suspended. But I walked out with the FBI and I asked the FBI, I said, why did you come with me? They said, Mr. Klaus, we came with you for two reasons. One, we wanted to see how you operated. Two, if you was going to get into a bind in here, where they're going to throw your butt in jail, we was going to pull you out. I said, well, what did you learn today? He said, we've learned how corrupt the system was. I said, what do you mean? He says, you walked in there and proved absolute corruption in that courtroom. I said, then go back in there and arrest the judge. They said, we can't. I said, why? Said, we don't have any place to take them. But we've never seen anybody walk in and do what you did. You actually used their own rules and regulations, and you beat them. Even though they found you guilty, you beat them. You proved corruption. I said, yes, that's exactly what I do. Well, then I went down, at that time, I went down to my state legislator. And I started asking him about impeachment procedures. And, of course, he sat back and said, well, Mr. Klaus, we don't do that. We don't get involved. I said, yes, you do. Yes, you will. I said, will you be here tomorrow? He says, yes. I says, good. So I came back the next day, and I brought in the Constitution for Florida, and I brought in the Constitution for the United States, and I brought in other federal documents, and I proceeded to explain the impeachment procedures to him. And he went, oh, my God. I said, what? He says, you do know how to do this. I says, yeah, I got to have you sit here and sponsor me so we can impeach this judge. And I've got FBI agents that will back me if we can get up on an impeachment. Well, he sit down and started to explain how I needed to file the documentation in. Well, it didn't go anywhere, but the point is, I walked in with the information of how it is done. I didn't walk in and say, well, I want to do an impeachment and I don't know nothing. I walked in with one of an impeachment and I laid it out how it's supposed to be done and who's supposed to be in charge and how this is supposed to work. And see, this is what befuddles these people. This is where so many mistakes are being made. We should not have to go through all this. And throughout the years of doing this, I've got to the place to where I started getting pretty brave, and I decided I wanted to do the private attorney general side. So I started bringing suits administratively, and this is one of the things that I have learned. Because I've watched people do regular Title 42 suits, 1988, 1983, and they filed their paperwork into court. I've sit back, I've watched these people. Are they wrong? No. Their complaint was 100% legitimate, but they had one problem. They didn't strip the immunity off these people before they went after them. And this is something that I've learned down here in North Carolina. Whenever I went after the police department down here, I went after the Department of Transportation down here, the sheriff's department, the court, the attorney general's office, the prosecutor, the judges, the highway patrol, the governor. The list that I went after, I started learning the proper administrative procedure avenue of going after them. So what I started doing is I started bringing complaints into the agency. So if you're dealing with a police officer, and this is what we did with in Ohio, when I had that problem with that run-in, I went to the mayor, I went to city council, and I went to the police chief. That is the proper administrative agencies that you deal with when you're dealing with a police officer. But we also went to the governor and the attorney general. And the reason why we went to the governor and an attorney general, because the governor and the attorney general is the one that signs for the Highway Safety Act, the federal funding that comes into that political subdivision. That governor and the attorney general agrees to the federal funding side. So everything that we're dealing with deals with federal funding. It deals with agencies. So when I went after North Carolina down here, we brought them into the administrative court. And of course, they came back and said here and said, well, you didn't follow proper channels here. And the attorney general came back in and said, well, they are not agencies or employees of the state. They're purely private contractors. And I went come back in the North Carolina statutes, dealt with the police department, dealt with the Department of Transportation, dealt with the Highway Safety Act. I said, no, here it is under federal funding. Here it is under your state law. Says these are state agencies. Here's the definitions. These people actually work for the state. They are employees of the state. They're collecting federal funding off the state. They're being paid off the state. And the attorney general came back in and made the issue again, and the administrative court came back in and said, well, Mr. Class, we're going to dismiss this because this administrative court has no subject matter over non-employees. These people are purely private contractors. And I flipped out. I can't believe these idiots actually did this. So I did an appeal. I went to an administrative judicial review court. So I asked for a second hearing on this. Well, I got up before the second judge up here in Raleigh, North Carolina, because that's where the administrative court was at. I went in before the judge, and the attorney general assistant was standing there in front of the judge, and he was real nervous. I had probably about 8 people with me, but I had 2 U.S. Marshals with me because they've come down to the house. They talked to me, and they wanted to know what I was doing. Matter of fact, they gave me a donation for a suit so I could show up there in a suit. So they showed up.
Oh.
Go ahead, hon.
I was just saying, wow.
But
they gave you a suit?
Yeah. They come down. They said they've been listening to me for a year and a half. They've been trying to find my flaws. They've been trying to find where I've been screwing up because they were told to. And they retired early because they said, Rod, we can't find any flaws in what you're saying. Matter of fact, what you're saying, you're actually proving the corruption of the system that we didn't know about because we're not being told this. So while we was up there in that court, the assistant attorney general told the judge, well, Mr. Class brought charges against the police department and DOV. And, Your Honor, they're not agencies of the state. They don't work for the state. They're purely private contractors. And the judge looked at the little assistant attorney general and said, excuse me, sir, these people come under the governor's office. They are agencies. They do work for the state. They are part of the state. And I don't know where you're getting your information from, but they do work here. Well, he looked at me and says, Mr. Class, what is your gripe? So I proceeded to explain this to him. He says, well, I'm going to take this under advisement. I will give you my decision whenever I get around to it. I said, okay, fine. So we walked out, and the U.S. Marshal sit there and said, Rod, I can't believe you hammered the Attorney General. You hit him up with their own rules, their own regulations. The judge actually agreed with you that you were right. But let's sit down and see what the judge does. I says, okay. So 90 days went by. 110 days went by, and I filed paperwork back off into the court. I says, excuse me, you have not answered my paperwork. You only had 90 days. And if you fail to answer my paperwork within 90 days, you have now prejudiced my case under your local rules. I got a letter back from the judge through the court stating that there was no such time limit. He had more important cases than mine. He had surgery done, and he's dealing with an issue with the school system. So I fired another document back in and says, okay, problem is, here's your regulations that says that you had to. So now one or two things is happening here. either you yourself are guilty of committing these same crimes, and therefore you don't want to hang your own people, or you've been threatened for your retirement. Well, I got another document back from him recusing himself because I intimidated him. So I was given another judge. I went up before Judge Ridgway. Well, we went back in for Ridgway, and there was another group of us. The U.S. Marshal showed back up. This whole courtroom was full. There was probably about a dozen of us that was in there. And I had another brand new Attorney General assistant in there. And he started bringing this stuff up, and the judge just told him to sit down and shut up. He says, Mr. Class, this is how it is. These people are private contractors. They don't work for the state. I says, good, that you and I talk private contract law. Because if they're private contractors, they have to come in compliance with federal funding. Because this state is receiving federal funding. The judge says, excuse me, let me rephrase that. These people are part of the local government. I says, good, that you and I talk local government. And I proceeded to explain what the local government was. And there was no place for police department, and there was no place for the Department of Transportation, for the DMV. He says, let me rephrase this. Every time I hit him up with their own regulations, he had to rephrase. We went through this about 3-4 times, and finally he just told me, look, I'm going to make my decision. I'll send you something in the mail within a couple of weeks. I said, well, let's make sure it's in a couple of weeks, because if you wait 90 days, you're going to be in violation of your own rules and regulations of bias and prejudice of my case, and I'm going to have to come back up here again. He looked at me, so we left, but the whole courtroom was full of attorneys. They locked us out, and they had a discussion in there. Well, 2 weeks later, I got a letter from Ridgway, the court order, saying that the case was dismissed. The administrative court didn't have jurisdiction because these people were purely private contractors. They were non-public officials. I said, thank you very much. That's what I needed to hear. They're not public officials. They're not law enforcement. They're nothing more than security guards working for Walmart. That's all they are. Well, I went down to talk to the local sheriff right here in Gaston County, down here in North Carolina. I went in and had a conversation with him. And I showed him this ruling that I got from the administrative court stating that the local police department were purely private contractors, non-public officials. And I walked in there with my PAG paperwork that I got from Congress, validating that I hold position as a private attorney general, and I walked in with the legislative enactments from 1866 all the way up to 1996, showing that this was a 100% legitimate position granted to the people by Congress, that we had that authority to walk in here. So I walked in and talked to the sheriff, and I started laying this stuff out. And I brought up about the manufacturer statement of origin, the MSO of your vehicle. And I asked him, I said, let me ask you a stupid question here. Seeing as how we went after the Department of Transportation and the police department on a driving license issue and a tag issue, who owns these automobiles out here on the road? He says, the state does. I says, and they own it through the MSO. Is that correct? He says, that's absolutely correct. Because they hold the MSO, they own the vehicle. I says, good. I'm glad we get this straightened out. I says, now, who owns your cruisers for the county? He says, well, the county owns them. I says, okay. I said, but you guys have to put your own gas in it out of your own pocket, right? He says, no. I said, you guys have to buy your own insurance? He says, no. I said, you guys got to do your own maintenance, right? He says, no, we got the city that does all this for us, the county. They put our gas in it. We got a credit card. They pay for the gas. They pay for the insurance. They do all the maintenance. They do all the upkeep for the vehicle. My deputies don't pay a thing for these vehicles because the county takes care of all of it. I says, okay. Now let me ask you a stupid question. If you and I can agree that the state owns all these automobiles out here on the road, including mine, so who's supposed to put gas in my automobile? He says, the state? I said, who's supposed to pay insurance on it? He says, the state. I said, who is supposed to sit down and do the maintenance for it? He says, the state. I said, that's exactly right. I said, now let me ask you a question here. He says, what? I said, you guys don't get a paycheck, do you? He says, well, we get paid every 2 weeks. I said, well, that's funny. I said, I don't get a damn paycheck off anybody. He went, oh, shit. I said, yeah. You know as well as I do. I don't have to make car payments, and I don't have to pay insurance, and the state's supposed to pick all this shit up. He says, Mr. Class, there's going to be a standing order to my deputies not to stop you. If you have any problems with any of my deputies, here's my phone number, and here is the chief phone number. You give either one of us a call if you have any problems with either one of our deputies. You call us before you do anything. I says, why? He says, because you have stripped us of our immunity, and now you can sue us in our private capacity. I said, that's exactly what I did, and that's why I'm in here talking to you right now, to give you a heads up. So we got that done with the county here with the police department. Well, then I had a problem with the Lincoln County because I was running a blue light in my Jeep. I didn't have it plugged in. I just had it sitting in there. And I was pushing the envelope on this. I had 12 sheriff cruisers from Lincoln County swarm my vehicle. Now, they didn't have no blue lights on. There was no flashing lights. They just swarmed my vehicle, and they brought the state insurance inspector with them. And here in North Carolina, the state insurance inspector is the one who gives the license to the bail bondsmen and to the bounty hunters. Well, because I have bounty hunter and PAG all over my Jeep and all over my excursion, they was going to get me for impersonation of a bounty hunter. So they brought the insurance agent in. The insurance agent and I sit down, and we got into our conversation. He said, well, Mr. Class, he says, you're not registered with the state of North Carolina to be a bail bondsman. I said, you're right, I'm not. I said, did you read my Jeep? It says 14th Amendment, Section 4, bounty hunter, public debt collector. I said, do you understand what this means? He says, oh my God. He says, you're a constitutional bounty hunter. I said, that's exactly what I am. He looked at the sheriff department and says, you can't touch this man. He is a constitutional bounty hunter, and you can't lay hands on him. He said, but Mr. Class, you can't have that blue light. I said, yes, I can. He says, you're not law enforcement. I said, oh, I most certainly am. If I'm a bounty hunter on the federal side, my obligation is to arrest you people for misconduct, and I already got one ruling that you're not police officers. You're nothing more than private contractors. Well, they hauled me into court, got before the judge. Prosecution said, Your Honor, Mr. Class had a blue light, and according to North Carolina statutes, that blue light had to be manufacturer original equipment. I said, I object. I said, you want to repeat that? She said, it had to be original manufacturer original equipment. I said, I object. I said, I can sit here and show you right now on your police cruisers. Your police cruisers didn't come from the dealership from Detroit where the manufacturer was. It didn't come with blue lights. It didn't come with the pinstripes on it. And your deputy and your symbols on the side. I said, you have a private contractor out of Charlotte that you take your cruisers down to, and they put lights on it, and they put your markings on it, and they put your sirens on it, and they put the roll pin in this thing, and the judge says, we're going to overrule that section of the law. He says, Mr. Class, you're not North Carolina law enforcement. You may be federal, but you're not state. And therefore, you can't have the blue light. The point that I hit him up on is when she tried to use original manufacturer equipment, I was able to come back in and show them not one of these cruisers come from the dealership, and the judge says we're going to skip that part of the law. This is the significance of understanding their rules and their regulations so you can show their errors in this. Well, I got involved in another case helping someone else, and we went after the sheriff department. And we got the ruling again from the administrative court that the sheriff department and the court system and the prosecutor's office and the attorney general's office at that time and the county jail were not state or county offices. They were independent contractors. They don't work for the state. So I got a second ruling on that. I did the same thing with the State Highway Patrol. I got into it, did the same thing. I got a ruling. They don't work for the state. They are purely independent contractors. That's the same thing with the governor's office. The governor's office is not an agency of the state. And I came back and said, excuse me, what do you mean the governor's office is not an agency of a state? It is an elected position. And the administrative court upheld the governor's office is not part of the state whatsoever. So I got these type of rulings by going after them. So what happened here by me doing this? I went into D.C. And of course I had my bounty hunter and my PAG stickers all over my Jeep. I had my vest on. I went into the House of Representatives down to the Judiciary Committee to file more paperwork because I was involved in another federal court case. I had to file paperwork in. I walked over to the Senate, to the Judiciary Committee, filed paperwork in. I come walking out. I come down walking to my Jeep, and my Jeep was taped off. I had about 6 cruisers and more than a dozen police officers down there, and one come up and says, is this your Jeep? I says, yes. He said, turned me around, he handcuffed me, took my keys off of me. They sit down and say, ask me, he says, Mr. Class, do you have any firearms in your Jeep? I says, no. I said, the problem is you don't know what a firearm is. He said, what do you mean? I said, you don't know what the legal definition of a fire alarm is. And they said, well, anything that shoots out a projectile. I says, no. I said, did you bother reading the 1934 National Firearms Act or the 1968 Gun Control Act or the Firearms Owner Protection Act of 1996? Did you read Title 26 under the IRS Code 5845? Or under Title 27 CFR under 479.11 under ATF that a firearm is, by legal definition, a shotgun that's been modified to a barrel of less than 18 inches, overall length less than 26, a rifle that's been modified to a barrel of 16 inches, overall length less than 26, a fully automatic machine gun, and a silencer. You're not going to find any of them in my Jeep. What you will find is a pistol and a rifle and my carry concealed permit that I got from North Carolina that allows me to carry. And besides, I hold position. I just went through Congress again. I got documentation stamped by the Judiciary Committee of the House and Senate to validate, again, my bounty hunter and my PAG position as legislative authority over yours. Well, this didn't go too well. So for about an hour, I was being interrogated. I had a couple of cops come up to me, want to know how I was doing, want to know where my buddy Carl was at, Carl Weston. I said, well, he's at home. He said, well, you helped us to save our home because you helped us file paperwork in, and we got our homes, and they dropped the mortgages on us. So we got talking here a little bit for about an hour, and they took me back to the barracks. Well, they took out my hearing aids. They took my hearing device for me to be able to hear, and they took my shoestrings. They basically stripped me down just to pants and shirt. They had me handcuffed to the wall. I was in there for approximately 3 more hours. I had FBI. I had U.S. Marshals. I had all kinds of federal agencies in there. While I was there, they were talking to me, and the one FBI agent made the comment. He says, you're one of them sovereign citizens, aren't you? I said, I resent that. I said, that's profiling me. I said, by the way, I said, you don't even know what the term means. I said, because if you would check North Carolina's Constitution, it says sovereignty lies with the people, and that the government is derived by the people's rights to create a government. So that does make me a sovereign. Because your system was derived from me, the people. I said, on the other hand, I've got Supreme Court rulings that says you guys are the sovereign. So which one of us is the terrorist? The one who's trying to enforce the laws, or the ones who's violating the constitutional protected rights and who don't know the law? So which one of us is the terrorist here? So they got off it, and they sit down and said, the FBI says, but Mr. Klaas, you don't believe in paying taxes, do you? I says, no, I don't. Why don't you feel you have to pay taxes? I said, okay, let me answer this question. I said, first off, get me out of this handcuff, get me my computer, and get me my hard drive. I will walk you through the congressional records. I'll show you why I don't have to pay taxes. So, well, we're not going to do that. I said, well, fine. I said, then has anybody got a Federal Reserve note in their pocket? They looked at me. I said, oh, come on now. Somebody has to have a Federal Reserve note. We don't know what you're talking about. I said, oh, I'm sorry. That's right. You guys get paid gold and silver, don't you? They looked at me and said, what do you mean we get paid in gold and silver? I said, well, if you don't get Federal Reserve notes, then you guys get paid in gold and silver. I said, well, we don't get paid in gold and silver. I said, has anybody got a little green sheet of paper that's got a 1 or 5 or 10 or 20 or 50 on it? And the FBI agent pulled out a $5 bill. I said, good. I said, what does this say across the top of this $5 bill? He says, Federal Reserve note. I said, oh my God. I said, yeah, Federal Reserve note. I said, do you know what a Federal Reserve note is? I said, do you realize that Congressman McFadden in 1933 and 1932 on the floor of Congress stated that the Federal Reserve note is not money, but a mere promise to pay you someday, and that Federal Reserve note under the Federal Reserve Act of 1913, Section 16, says this is a Federal Reserve stays with the Board of Governors and the Federal Reserve banking system, and it is only issued to a Federal Reserve agent only, and it is the obligation of the United States. I said, could you sit here and tell me how I'm supposed to pay taxes on something that is a promise that is only internal currency? They looked at me and they got off the topic. Well, we started explaining. I started giving a mini seminar to these guys. Well, the 3 hours that I was doing it, roughly every hour, they had to switch a different group come in because I was overloading them with so much knowledge, and I was backing it up. I was telling them where it was sitting at in the congressional records. I was telling them where it was at in the statutes at large. I was explaining it to them, and I think what they were doing is going out there in my computer and they were checking it and validating it. Well, after about 4 hours with these idiots, the U.S. Marshals finally told the D.C. police, he says, Mr. Klaas is not a threat. We're not going to do any charges against him. And that's what the FBI told him. He said, he's not a threat. Well, D.C. wanted to push the issue. Well, then that's when they decided to Mirandize me. They sit down and ask me, I have the right to remain silent. Anything I say can and will be used against you in a court of law. If I can't afford an attorney, one will be appointed to me. They said, do you understand this? I said, yeah. Well, I signed that little sheet of paper. Well, after I signed that sheet of paper, I asked them a simple question. I said, now, you guys have finally Mirandized me after 4 hours. Does that mean that all the evidence that you took out of my Jeep and all this questioning that we've done here for the last several hours, that means you can't use any of this, right? And the 2 FBI agents and the 2 U.S. Marshals said, oh, shit. I said, yeah. I said, you guys got into my wallet, did you not? I said, yeah. Did I not have a Miranda card in my wallet? And you didn't see this? And you're going to question me for roughly 4 hours? and then Mirandize me after the fact? I said, you can't use any of this information. Well, they put me in jail for the weekend. They handed me a public defender that came up to me, and I was supposed to talk to at the window. Him and I had to go around. But he said, Mr. Klaus, he says, my job is to get you out of here. He said, and that's what my job is get you out. Just shut up and let me get you out. So we sit down, we talked, we went up before Judge Sullivan. The prosecutor cross-examined the police officer, and when it come time for Dworsky to sit down, Dworsky told the judge, says, Your Honor, Mr. Klaus here holds position as a private attorney general and a constitutional bounty hunter through Congress. I've already validated this. Judge Sullivan looked at me. He says, Mr. Klaus, we're going to dismiss your case. You get your Jeep, you get your stuff, and you get out of D.C. You're no longer allowed in D.C. You're barred from ever coming back here. So you get your stuff and you get out of here. I said, okay, fine. So I went down to the police department. And I got walking down the street, and I didn't know for sure where it was at. And I come up to one of the police officers. And I showed him who I was. He says, you're the one. I said, what do you mean I'm the one? He says, you're the one that has got this place terrified. He says, these people are absolutely scared of you. I said, what the hell did you do to these people? I said, you want to know what I did? He says, yeah. I says, I went down to your law library. That's the Library of Congress? He says, yeah. I said, I learned how to read your books. And he looked at me. I says, yeah. It wasn't the gun I had. It was the knowledge that I possess. It is the understanding that I have. I said, and this is what terrified them. Because I knew too much. That's what the attorney sat down and told me. He said, Roger, you know too much. Well, when I went down to the police department to get my stuff, well, the prosecutor decided to re-indict me and bring me up before a grand jury, bring me in for another hearing. So I got the case dismissed once, but they decided to run me back through the ringer again. Well, getting ready to go home, I had to come back up. I wasn't allowed to have my Jeep. I wasn't allowed to have any of my stuff. But when I came back up, they returned my Jeep to me and my computer, and at that time, they brought me before a grand jury. Well, you're not allowed to go before a grand jury. They don't allow you before a grand jury, and I insisted on it. I said, I am going before your grand jury. I have a right to talk to your grand jury. So when we got in there to the grand jury, I proceeded to explain what I ran into. I said, you have up here a definition problem. I said, I was charged for a firearm, and I did not have a firearm. I had a rifle, and I had a pistol. And if you're going to charge me, you have to charge me under the true legislative name of these stuff. I said, not only that, your Heller case versus D.C. and your Parker versus D.C. case up here made your gun laws unconstitutional, as well as McDonald versus Chicago. Well, the grand jury sitting there said, well, what that means is we can only have it inside the house. I says, no, you've been lied to. You're allowed to have them. And they said, well, Mr. Klaus, your permit is not valid here in North Carolina, up here in D.C. I said, yes, it is. I said, my permit comes under Article 4, Section 1 and 2 of the Constitution. Full faith and credit from one state to the next. Also comes under the 14th Amendment, Section 1, equal protection under the law, as well as Title 42, 1981, equal protection under the law. I said, so you have to allow my permit to be up here. I said, well, the problem is D.C. is not a state. I said, yes, you are. I said, I can walk you through the laws and show you where it is declared to be a state. You may want to play both sides of the fence, but the bottom line is the laws come from here. And you spread it out to us and our states. And if you're going to spread your stuff out here to us, you're going to have to allow my permit because you accept my driver's license. Well, the prosecutor sat here and told the jury that you only have one decision to make. Did Class come into D.C. with this firearm, rifle, pistol? Did he come into D.C. with? That's the only decision you have to make. Did he do this? And of course, that was a slam dunk. Yes, they found me guilty. Well, then I started going into the federal court because they transferred me from the Superior Court over to the federal court. I got in front of Judge Wilkins. And Judge Wilkins sat here and swore me in and says, Mr. Class, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth, so help you God. I says, yeah. He says, now, if you commit perjury, if you lie under a sworn oath, then you can be charged for contempt of court. I says, now, wait a minute. I said, let's you and I have a talk here. Are you telling me that anybody who takes an oath, if they lie, that's perjury and contempt? I said, even on your side of the fence? He says, it most certainly is. I says, good. Let's talk about what your prosecutor did. Did he not take an oath to the Bar Association that he would not mislead, misconstrue, put false information before this court? Did he not swear that he would uphold the Second Amendment? The judge says, well, we're going to postpone this hearing. I said, we're going to postpone it. Well, then we got up in front of Judge Kessler. And my public defender sit down and talk, but they was plead me guilty throughout the whole thing. And I got a chance, I interrupt. I said, hey, I ain't going to represent myself because I've already filed a bunch of paperwork in. I filed a bunch of paperwork in for an in-camera hearing to where this was put on the private side. I went back and filed in everything that they were doing wrong. So when I got a chance to talk to Judge Kessler said, I said, well, Mr. Class, you really don't want to represent yourself in here because you have to know the rules. You got to know the criminal rules procedure. You have to know the rules of evidence. You got to know the local rules. And, we as attorneys don't know all this stuff. But, for you not being educated in the law, it's really going to be harder for you. I said, that's all right. I'll handle it. So she postponed, got another status hearing. I walked in. I filed paperwork in under Rule 12 that I have a right to file paperwork, and I filed my own int of appearance into this thing. Well, when I filed my int of appearance in, I made the separation of the all-capital name. I showed all capital United States of America versus Rodney Class, ward of the state, a state name. He is the trust for the state. Then I come down and put my Rodney Dale Class in proper English as third-party intervener, private American national, private attorney general. So I made a separation between the all-capital name and the living name on this. And I filed my paperwork. I filed my int of appearance into this thing. Well, they accepted my int of appearance. So that allowed me to come in and start filing paperwork in because I got rid of my public defender, even though they had him on the sideline. So when we got in there, and Judge Kessler proceeded to talk to me about, well, Mr. Class, do you have your paperwork? I says, no. I said, I'll file paperwork into the clerk of court. I have not got nothing back. They're sitting on my paperwork. She said, well, you're supposed to be electronically filing this thing in. I said, I can't file this electronically in. That's only for attorneys. I'm not an attorney. I'm a private attorney general, but I'm not an attorney. I said, I can't file it in. I said, I have to send mine in with registered mail with a envelope, pre-stamped, pre-addressed. All your clerk of court has to do is go stamp, stick it in the envelope, throw it in the outgoing mail for me to get it back. I said, I ain't got squat back off your people. I said, I am here to talk about the rules. I had two little books that came from the Judiciary Committee, from the House and Senate, the Rules of Evidence and Criminal Rules Procedure. They're a very small, thin book. Then I ordered online a heavier book that dealt with a whole lot more information. It was an annotated version. I looked at Judge Kessler and I sat down and said, now, which one of these books do you want to talk about? You want to talk about these little cheap, flimsy ones, or do you want to talk about the annotated one, which has all the case law law and the history and the foundation of all these rules. Which one would you like to talk about today? She looked at me and she says, we'll go with those little ones. I said, fine. I said, but I want this big book put in here as evidence into the record to show that you're not following the rules. I said, now, let's sit here and start out. Let's start out with Title 28, which is Judicial Procedure, under Title 2255. 2255, which is habeas corpus. I said, you do understand if I prove constitutional violations or statutory violation, you have to dismiss my case? You do understand that, right? Because your rules sit here and say, under the rules of evidence, under 402, that the Constitution is admissible evidence already put into the record, and the statutes are already admissible evidence, and these rules are already admissible evidence, and Supreme Court decisions are admissible. That's the same thing with 501, and under 802 and 902, it talks about prima facie. I said, but let's go back to 2255. Let's talk about the constitutional violation. I said, first off, let me ask you a stupid question. I said, who is the corpus delicti in this case? Who's the injured party? And she was stammering around and stuttering with the word corpus delicti, and she was sitting here asking the prosecutor, do you understand what he's asking here, corpus delicti? I said, quit this. I said, you guys were first-year law students. You were taught who is the injured party. And she would say, well, Mr. Class, you violated the statutes. That's the corpus delicti, the statutes. I said, do you really want to tell me that? And she says, well, yes, you violated the statutes. I said, good. Now, let's get into the habeas corpus side. So I proceeded to explain Article 4, Section 1 and 2, full faith and credit. The 14th Amendment, Section 1, equal protection under the law. Title 42, 1981, full faith and credit and equal protection under law. What one state gives, you have to give me in this state. I said, now, as you sit here and said, Mr. Class, you broke the statute. You violated the law. Let me walk you in and show you where your prosecutor, as he is a bar agent. He is a federal bar agent under Title 36, United States Code, Chapter 705, Section 70503, that sits here and says if he does not uphold the Constitution, he does not uphold the statute, he has disqualified himself. He is now disbarred. I said, you do realize that he has violated the Constitution and the statutory law under Title 36? He has now disqualified himself. He has violated the law. He has advocated the overthrow of the Constitution, which is a violation of the Smith Act of 1940, which is an act of treason. And you do understand that he's violated Title 18, Chapter 175, 2385, which is insurrection, sedition, rebellion, and treason. I said, why is this man still sitting in this courtroom? Why is he not being charged for treason? And I started to go through this stuff for about 35 minutes with her. As she looked over at that prosecutor, she said, can you rebut this man? He dropped his head. He shook his head. No, he could not rebut one single thing I said. I said, on top of it, you didn't even Mirandize me after 4 hours of interrogation. And she said, did you Mirandize this man? And he shook his head, and she screamed recess, and she ran out of the courtroom. The entire time that we're going into these courtrooms, when I have a chance to talk, I am sitting down and I am hammering them on procedural violations. I'm hammering them on statutory violations. I'm showing how they violated their oath as an attorney for ethical violations. Well, after being in there with her, she got out of this, and I ended up with Judge Roberts. Judge Roberts was the chief senior judge. So now I'm on my third judge. I've had 3 prosecutors up to this point. And we got in before Judge Roberts. Judge Roberts sit down, started talking to me, and because me having a hearing problem, they had to give me a hearing device throughout this whole conversation with what we're doing here. But the prosecutor come up and said, well, Mr. Class came into D.C. and he had firearms readily accessible. And I objected to that because it wasn't readily accessible. It was inside my Jeep and it was locked up. But I brought up to the judge, I said, I want to tell you what. I said, let's you and I have an understanding here. Let's talk about this. I said, first off, your underling, which was Judge Scully at the time, Judge Scully just ruled here back in July 2014 that firearms were legal and that he upheld the Tom Palmer case, which was part of the Heller case and the Parker case, because he was a defendant in this. He upheld that your gun laws were unconstitutional. I said, he just made this ruling. I said, not only that, I says, under Title 18, Section 930, your property had to be posted. Under Section 8, it sits there and says, if you don't post it, you can't get a conviction on me. And the judge looked at me and says, well, we're going to have that ruling overturned. I says, good. I said, then let's go with what Thomas Massey said here and put in for a bill before legislation that he's going to defund the District of Columbia. He's going to see that the District of Columbia gets defunded. And he sat down, he looked at me like, how did you know this? Well, all through this is through research. We said, we're going to set this up for another status hearing. Well, all the time that I have got close between Harvey and I with what he's been helping me on, we got close to some 70-odd documents that we've been throwing into this thing. And we've been hammering them, anything from the fact that these people were not American citizens, and we explained prior to the Civil War, to the Reconstruction Act, on how the federal government walked into the South, it took them over at gunpoint, told the southern states, you will relinquish your state sovereignty or we will shoot you right here, right now. They had to relinquish their state sovereignty, take on the federal side of this thing. That 14th Amendment was the verification that the state came under the federal government, because the 14th Amendment only applies to them and their kind, because if you get into Section 2 and 3 of the 14th Amendment, it deals with the president, the vice president, the legislators, and the whole 9 yards on their side of this fence. There's nothing that deals with freeing the slaves at that time. There's nothing in there. It dealt with public offices. Well, then we went back and showed where the D.C. is a corporation. And when they created the corporation, they dissolved the government. In 1945, we went back in and we showed the 1945 International Organization Immunities Act is that all these public offices were turned over to the UN. So we don't have any public officials. Everybody expatriated except for you and I. You and I are the only ones who have never expatriated. This is what we come back and we start hammering them in our paperwork on. But we started hammering, and the more I started hammering them, I've had right there at the end I had the public defender and the U.S. attorneys pulled me off to the side, and they told me, said, Rod, said, we got one problem here. You know too much. You're walking in here with too much knowledge. We know you are right. We cannot allow. This is where the problem's coming in. He says, you know too much. And if for us to sit down and allow you to win, you would overturn every single court case in this country. When I got into my February 9th hearing, which was my final hearing. Well, I was forced into a plea agreement because they didn't allow me to do it. They was going to give me 21 years if I didn't agree to the plea bargain. Why? We got a lot of noise out here, and no one ain't on my side. Well, what we did is when I went in for my final hearing on February 9th, Judge Roberts asked me, he said, do you have any objection to your plea agreement? I said, yeah. I said, first off, your prosecutor lied to me. Your public defender lied to me. Your laws have been overturned. You guys lost your federal funding. I said, and I was forced into a plea agreement because you guys violated constitutional protected rights and the Second Amendment. So he looked at me and says, okay. He says, now, what's going to be your final statement here? And I proceeded to explain. He says, well, you can go file for an appeal. He says, you can do it under informer paupers. He says, because you know there's no money. I said, that's exactly right. So he allowed me to file informer paupers. But everything that we've done up to this point, Angela, a lot of these guys out here, they're not wrong on what they're saying. They're just not carrying it far enough. I went in this thing with the intent of being a prosecutor. I went into this thing to hit the shit out of these people. I went in here to expose the fraud. I'm not interested on trying to trim bushes with these people. And that's where a lot of the stuff, if we could trim the bushes, this is ideal. And I don't have a problem with that. Now, you've got a lot of good people on here. Their knowledge is wonderful. They got the right concept if we're dealing with a legitimate court system. I did not walk into this court to defend myself. And that is where people having a mistake and having a bad idea with what I did not walk in here to defend. I walked in here to prosecute. I walked in here to hammer these people. And that is something that they're not used to. They're not used to having someone come in and tear them apart. They want people to come in and try to dance around the system. I'm going to put this in the same perspective of what is going on here. They're not wanting to put the fire out. We need to keep the fire going. Because if we keep the fire going, we can keep our bitch going. With what I did in D.C., and I don't know how much it played, but with what I hammered the D.C. on, their gun laws have now changed across the country. I didn't do this for one or two individuals. I did this for the entire country. In the way I went after this, it opened it up for the entire country because the gun laws are being changed. Judge Scully just ruled again here last week in a second decision that D.C. is constitutional. It has no standing. And this is where one of the big differences with what I teach compared to what Carl teaches and what teaches and what was going on with Tim Turner and his bunch. But these guys went to jail. I'm not sitting in jail. I didn't get no jail time. I got jail time for contempt because I didn't show up. But I never got jail time for the gun charge. Put me in jail. This is where the issue's coming in. This is what I have done. Like I said, there's a lot of people don't want to run down this path because it is complicated, but it is not as hard as what you think it is. Any questions, Angela, or have I lost you? Angela? Sound like NSA is sitting down playing with the internet. Angela, you got any? All right, go ahead and sign off and come back in. Angela is signing, going out and going to come back in because I don't know if the noise is on her side or where it's at for sure, because I got my side muted for my listeners. But you've got a lot of wonderful people out here, and they got a lot of wonderful ideals, but they're just not going far enough with what they're doing. It's like you can sit back and say, I have a BMW emblem. An emblem does not give you the car. And throughout the years, we've learned to put pieces together. I may not have all of the pieces, but we've got enough with what we have here to expose so much on their side. And we are working on a PAG school that's going to be coming up here in June 27th over in Arkansas from June 27th to...
Can you hear me now?
Yeah.
Oh, my God. I don't know what was going on. I didn't hear any noise. People in the chat said they were hearing noise big time, and I didn't know where it was coming from. I unplugged my headset 3 times, so I guess it's on the TalkShoe, and I don't know. I mean, not TalkShoe, Skype, because I just got out of Skype and then came back on. And is it okay now, or is there still noise?
No, we're good now. We just had a lot of static going across this thing.
I hate when that happens, and I don't know what causes it to happen. I really don't.
NSA.
Probably.
They don't like what we're teaching.
Mm-hmm.
They don't like the knowledge out here. But the thing of it is, Angela, I've had FBI come to the house. I've had U.S. Marshals come to the house. I've sat down with these guys, and we got a retired FBI agent that came down here in July last year to the campground. And all these people have come to me with the intent to prove me wrong. And when we start laying out the statutes at large, where we went back into the 1935 Social Security Act under Title V, Section 501, 502, and we're sure where there's a $1 million price tag on us at birth each fiscal year, she crapped. When I started showing their public offices is under UN, and they're not part of the United States anymore. They crapped. And this is a significance, because I get into the historical side of this stuff. Because when people coming up and asking me, Rod, where does it say that a name is a corporation? Well, I will take them over to Delaware Administrative Code under Title 8, which is corporation. I'll bring them into Chapter 6, Section 617, says their last name is a corporation. It's come out of corporate law. We'll take them into Texas Administrative Code under Chapter 79, which is corporation, under 79.31. It all has to be capitalized, because that's the only way the system is recognizing a corporation, through capitalization. That's the same thing with the style manual. So what we bring in, Angela, is I bring in the historical side. I show people where this stuff is at. So when you're walking in and you're telling the judge that all capital name, or that I am not a person. And when I did this with Kessler, she sent me down to a psychiatrist. And I had a psychological evaluation that day for about an hour and a half, 2 hours. I got in there. I talked to the psychologist. I started going through a bunch of questions, and I started explaining stuff to her. And the first thing she started doing was saying, whoa, you're talking over my head. You're talking over my head. I said, excuse me, what do you mean I'm talking over your head? I've got a 12th grade education. You've got a college degree. I am being told there is no excuse for not knowing the law, and you're telling me that you don't know the first thing that I'm talking about, and you're here to evaluate me when you don't have a clue what we're talking? She gave me a flying bill of health and sent me right back up to the court. Set it up. He passed. There's nothing wrong with him. He's more than capable of defending himself. This is what we're coming in. I've talked to too many guys that's walking in here and saying, well, I'm incompetent. I don't know. I'm stupid. The moment you do that, you hang yourself as far as I'm concerned. When I can walk in here and I can put a psychiatrist to shame, and I can sit here and walk her through this stuff, and I can sit there and show them exactly what I'm sitting here talking about, and they're telling me that I'm talking over their head, that is something that is a pat on the back of what we're saying. They're not sitting down saying that they don't understand. They're telling me I'm talking over their head. So they're acknowledging the knowledge. They are acknowledging what we're sitting here saying. This is what the judges, they're acknowledging, but they've never had anybody that just walked in and hammered them, because it's like what I dealt with up here in Raleigh. When that judge sat here and said, well, Mr. Class, they are private contractors. When I started to hammer him, he switched jurisdictions on me. He switched topics. He said, oh, well, they are local government. I had to move with him for the local government. And when he went to the next topic, I had to move with him. I had to sit here and show him. I knew what he was talking about. I showed him where it was at and how he was wrong. And that's part of the problem that we're having out here. You can walk in and you can make a simple statement, but if that judge takes you to the next level and you can't explain it, you're sunk. I had a couple back in 2008 when I first did the Corn Novus paperwork. There was a husband and wife team. They lost their kids to the state. The court separated them so they wasn't together. They both had to hire an attorney, and they got rid of their attorney. They came to me. We filed paperwork in. The judge threw out the husband's paperwork on a Friday. Monday, the wife went in, same paperwork, and he looked at her and says, okay, I want you to explain the paperwork. She said, what? She says, I want you to explain the paperwork. She says, okay. So she proceeded to explain about his oath of office being under Title 22 CFR, Foreign Relations, 92.12 to 92.30, on how the oath of office had to be done. She took him over to Title 8, United States Code 1481, under alien residence, and showed him the moment he turned around and took his oath, he relinquished voluntarily. He relinquished his national citizenship and became a foreign agent. And that's where he stopped the court case at that time. Because she was able to walk with him as he went through the different jurisdictions. She was able to walk with him. When they got their paperwork from Child Services, they sent the paperwork to me. I showed them how to read their paperwork. They went into court and the judge said, oh, we made a mistake. This is the wrong jurisdiction. So they came back in another sheet of paper. I walked them back through. This judge did this 7 different times of acknowledging they had the wrong jurisdiction. After the 7th time, they got their kids back. This is the difference in what I'm teaching on what and how I do things. A lot of people feel that you don't have to know the rules and regulations. My attitude is you have to know their job. If you don't know what their job is, how can you tell them where their errors are at? And if anybody has ever watched and spent the time watching C-SPAN, or you watch the government legislation channel, I caught it here the other night. They were talking about Medicare. They're talking about the legislation. Not one single topic was ever talked about John Q. Public. When they was talking about that Medicare legislation, it went back to the agency of the government on how they were to operate, how they were supposed to be helping, and how it was supposed to benefit the American people, not rip them off. And this is what I'm sitting here saying. This is what I did when I went up before Kessler. Because when we got into 902 under the rules of evidence, and we started to explain the prima facie side, I walked in and showed her in 1925 the statutes at large stopped on March 4th, 1925. Volume 44 picked back up on December 16th, 1925. So between volume 43 and volume 44, there's roughly like 9 months that were missing. Supposedly, HB 10,000 was a legislative bill on December 7th, 1925, codify the statutes at large to make the United States Code. I walked in with the statutes at large, and I sit down and says, number one, we have a problem. You can't charge me under USC codes. Why? Because under prima facie law, and here's your statutes at large, that shows that your law stopped on March 4th, 1925. Supposedly, HB 10,000 was passed on December 7th, but here is volume 44 that shows that it picked up on December 16th, which was 9 days after, supposedly, it was passed. It shows that it was never passed. It shows that in 1935, and here is the Federal Register, where Congress allowed the president and created the Administrative Committee, allowed them in 1935 to codify the statutes at large for administrative use only. And here it is under the Industrial Recovery Act of 1935 that shows that the USC codes are purely administrative and it only applies to you and your kind and not to me and mine. And she looked over at the prosecutor and says, can you rebut him? He shook his head, no, he could not. I said, here's the proof. Your laws don't apply. This isn't me telling you your USC codes don't apply to me. Here it is in legislative acts that shows that your USC codes don't apply to me. Here is the definition of the word person. That word person is under Title V, USC Code, under 552A, and it says a person is an individual, and it defines an individual as a U.S. citizen or an alien applying for permanent residence. That U.S. citizen don't apply to you and I. That's that 14th Amendment citizen. We're American nationals because whenever they relinquished their citizenship under Title VIII, 1481, they walked out of their American side of this thing. They walked into the foreign side. And this is what we're coming back in. This is how we're hammering them. They could not rebut. They could not disprove their own congressional records. This is why, with what I'm teaching, it's difficult, but if we will start taking the time on individual cases, we can start hammering these people. There isn't an area that I can't get into, whether it is IRS, whether it is child services, whether it is criminal, whether it is traffic. There isn't an arena that I can't walk into and bring up their own statutes, which is most people they can't. And it's understandable. But I've had a lot of time here on my hands to go back and research this. But a lot of stuff that like Carl Lutz has come up with and Thornton has come up with, they have given me a lot of information for me to come back in and look at. And I try to improve and add to and show where its stuff is at. There's nothing wrong with their material. They got some of the best material out here. It's just that I sit down and I'm able to walk into any jurisdiction with a judge And I can walk in, and this is what actually flabbergasted the U.S. Marshals, and this is what flabbergasted the FBI when they watched me work, is that there wasn't an area that I could not walk that judge through and hammer that judge and show where they were wrong. I've watched too many people walk into a courtroom that is got set up on one little thing. As long as that judge stays there, they're fine. The moment that judge sits there and says, well, you know what, I really don't give a rat's rip, and we're going to go do this to you, and you freeze. You don't have anything to sit here and say, you've lost. And this is where I have been able to hammer them. I have more information than they've got questions, because every time they ask, I give them an answer, and I tell them where it's at. And after a period of time, they don't play no more, because like I said, every time I turned around, they kept postponing my hearing. I started out on May 30th, 2013. This thing got dragged out to February 9th, 2015. I dragged them out this far on hammering them, and now I'm in the appeal side of this thing. But I hammered the prosecutor on some of the issues that within 14 days after I filed paperwork, he had to address my paperwork. But what was going on, all my paperwork, when I sent it in, it went to the mailroom. It went straight into the judge's chamber. Why? Because he made it in camera. He made it private. And when it went into his chamber, it was sent there for about 2 weeks, week and a half, 2 weeks. Then it got sent down to the clerk of court in another week, week and a half, 2 weeks. They finally logged it in, but when they logged it in, they sealed it for public viewing. It was not for public viewing. They sealed my case on all my documentation, except for just a few of, like my interview appearance. But I also know, from what I was told, my paperwork went up to the United States Supreme Court, because I have an informant in there that sat down and told me my paperwork was up there. And they were told to seal my paperwork, because if my paperwork got out and the public actually knew this, it would overturn their system. But thanks to Harvey, with what we were doing, as soon as it hit the courthouse, I had Harvey posted on the big list. So this way, it was always in public viewing. It didn't matter what the court did to it. I sent it out to Harvey, and Harvey posted it on the big list to get it out.
So where do you stand today?
Well, right now, I'm waiting for the appeals court to answer my paperwork, because my brief was put in on March 9th. The United States Attorney had 30 days to answer my paperwork, which was April 8th or 9th. They haven't answered. I filed a non-compliance first notice into them. They had 15 days to ask for an extension. They did not ask for the extension, so on the 16th day, they got their second notice to sit down that they did not comply, and I'm asking for a judgment in equity. And it's sitting there, and I finally got my transcript notice from the Superior Court, and Judge Sullivan turned it down, says I'm not entitled to my transcript because my case was dismissed. So I now have Judge Sullivan dismissing my case. I have Judge Scully that made a ruling that the laws were unconstitutional. I have the Heller case. I have the McDonald case that shows that the laws were unconstitutional. I have the Sixth Circuit Court out of Ohio that shows that the gun laws were unconstitutional. I've got the Ninth Circuit Court out of San Diego that came back and ruled that the gun laws are all constitutional in 2014. So I've got 3 solid rulings in 2014 that shoot the snot clean out of D.C.'s gun laws. And we got this sitting before the appeals court. And right now they really don't know what to do with me, but I do believe part of their procedure, Angela, is they have to read and go through all my documents. They have to sit down and see if I made these issues in court. I can't say I made it. They have to go back and read my paperwork and see if I've actually made these issues. And I think what's taking them so long is they're going through my paperwork and they're crapping. Because if they turn around and they overturn my case, this now means everything that I filed in now has to be put on the record for everybody else to use to go back and show the fraud. And this is where their dilemma's at.
They keep ruling against you, though. I don't know.
Well, they could, but the problem of it is
they don't care.
Well,
they don't care.
Well, they don't.
That's what it seems like to me. They like having us jump through hoops and then come back and have to fight this and then fight that and go here and there. It's just, they don't care.
Well,
you remember that video you sent me of the judges' conference?
Yes.
A million years ago?
Yep.
Okay. And do you remember at the end of it? I mean, it was really a good copy you sent me because the ones that have been posted online, you can't hear half of the stuff that's going on. But the one you sent me, and I wish I could find it, I'd repost it, but I don't know where it is. Is it online?
No, they've taken it offline so many times.
Okay.
But,
well, at the end, do you recall at the end when they brought up IRS, they were talking about taxes?
Yep.
And the judge in the audience said to the judge on the panel, we can't let those cases, we have to nip it in the butt. We have to stop those cases as soon as they get to us and not let it go to the Supreme Court.
Yep.
And that right there tells us they don't care. They're going to do whatever they want to do to keep their little charade going and to keep the people stupid and paying through the nose for all the fines and fines, whatever, penalties and or keep you in jail. I don't see. I think you're fighting to the death, and that's, I guess, a good thing because it shows you're an honorable man. But they don't give a shit. They don't care.
Well, they don't. But see, what has helped me is what's coming.
I can't hear you.
What has happened here is
Thomas. What happened? Did the volume go down, or is it just me?
It may be you. I'm still here. Hello.
All right, I'm turning up my volume. Go ahead.
Thomas Massey. Can you hear me?
Yeah.
Thomas Massey got his legislation passed that if D.C. does not allow carrying guns in D.C., they will lose their federal funding. And he got his bill passed. And this is one of the things that Judge Scully is going after, is the fact that if they don't sit here and comply with the Second Amendment, they're going to be defunded.
You actually believe that?
Yeah, because I've watched it happen in Ohio. I watched it happen in Ohio for 6 months. The police department and the sheriff department and the county jails lost half of their facility for over 6 months because the federal government came right into Ohio and says, you misused the federal funding. We either want our money back or we're going to cut your federal funding and we're going to shut your jails down. And that's exactly what they did. They shut half the jails down.
But they're back they're back today, back at full capacity again, or?
Yeah, well, they start going back in compliance with the federal funding. But yeah, it does happen. I'm a firm believer in that.
I'm glad you are. I've lost faith in the system. I believe whenever they come out and say in public, I mean, whatever, let me put it this way, whatever they say in public is almost a guaranteed lie, Yep. Read my lips, no new taxes, whatever they say in the public is to appease the public. But then they go back to their normal routines. They don't give a shit about you or me.
Well,
they're going to keep doing what they're going to do. They're not going to cut their own throats. I say that all the time. They're not going to cut their own throats just so that we, get things the way they should be. They just don't care. And as long as they've got the cops, with the guns and, I don't know. Call me crazy.
Have you watched the new stuff that's come out of D.C. where 3 D.C. police officers either in the police station or in one of the congressional buildings has left their pistol in a bathroom?
Oh, yeah, I heard about that. That's funny.
Yeah, the thing of it is we're starting to see where states are starting to allow people to start carrying. So if it wasn't for this D.C. case, and I'm not sitting down trying to take all the credit for this, but I'm sitting here saying I think there's so much of my paperwork has got out to these other Second Amendment groups, and I think Judge Scully may have got into some of this and didn't realize a lot of this. But he is hammering the shit clean out of D.C., out of their police department. He's putting an injunction on them.
Well, I hope for the best, but I just don't trust them, you know.
Well, no, I don't either. But
and but didn't you have a one of those electronic bracelets on your ankle or something like that?
yeah, they put a GPS tracking device on me. I had it on for about a year and a half, and that was strictly to keep me out of Washington, D.C.
Yeah, jeez. That's such slavery. The only thing that's missing is the chain that's attached, right?
Well, the thing of it is...
Is that what they put on the slaves, you know, ankle chains?
Well, what was funny is that when the probation officer come down, and they sit down and says, we have never in our life ever had an order to put a GPS tracking device on somebody to keep them out of a town. Normally, this GPS tracking device that you have is for child molesters, is to make sure that you don't go around parks and schools and where kids are at. But
how'd they get away with that? I mean, did you agree to let them do that?
I didn't have a choice in the matter. They sit down. I filed in my paperwork objecting to it because it was peonage and that it was involuntary slavery. And I laid all this stuff out, you know, but they walked right through it. But this is fine because, like I said, with what we have, we got this on an appeal. If this appeal goes through and I win, we're going to bring back a lawsuit because, see, we've already got the SF-95 tort claims. I've already got permission from the Sergeant of Arms of the House and Senate and from the United States Administrative Court and from the DOJ professional responsibility that I could sue these people in their private capacity and they strip them of their immunity.
Yeah, but who's going to hear it? Who's going to hear the case? Who's going to hear the lawsuit? One of their guys, right?
Well, they are, but the thing of it is, Angela, we can sit back and we can throw our hands up, and it would have been very easy for me to just say, screw it, don't fight them, just comply.
Well, no, there are other ways, but, you know, we all have to find our path. But there are other ways of dealing with them, isn't there? I mean, fighting isn't necessarily the only way to deal with them. You're fighting them with, you know, using their codes and their rules and their regs and their statutes and, you know, everything you're using is theirs. I mean, so...
It's their regulations. But we have to start someplace. We have to start someplace. And because, you know, you can't have the attitude, well, it's a no-win situation. I'm not going to win, so there's no sense in fighting. I might as well just take my screwing, and I might as well just bend over and supply my own Vaseline.
No, I'm not saying that at all. I'm just saying that, you know, what's that saying? You know, if you do the same thing over and over again and expect a different outcome, that's insanity. I mean, maybe there's a different way to go about it. Have you looked at anybody else's methodology, or I mean, you've been fighting for so long, Rod. I've been watching you fight for.
But we are
for 12 years. I mean, geez.
Well, what we're working on now, and I don't know, if it's going to work or not, but we are trying to get what is known as the International Tribunal for Natural Justice. It's an international organization that watched my court case. It's international. And it's a bunch of international people that's trying to get this up. They asked me to come on board because they'd never seen anybody lay out the amount of evidence and absolute corruption in a court system. And they're trying to get an international court up. It's going to take time.
You know, I wanted to ask you about your paperwork. Is it posted somewhere?
Yeah, Harvey.
Where people could look at it?
Well, if you were on the big list, it is all over the big list. Let me bring Harvey in here a minute.
Yeah, type it into the chat. That way we've got a permanent record of it there.
Okay. Let me.
Is that the Ray Servers one?
Yeah. That was rayservice.com. You got to go into it.
No.
That's it. All right, Harvey, you there?
All right, Angela, Rod.
Yeah.
It's no longer on Ray servers. It's on It's on Dropbox, Angela. I'm not on your board. I'm on Rod's board for right now. Maybe I'll shut mine.
You want to tell me what it is? I'll type it in. I've got Dropbox. What?
No, it's too long. Let me. Would you send me an email and I'll send you whatever you need. Okay.
Are you on Skype or?
I don't understand Skype.
Okay,
Mentor
so an email.
2.
Where am I? Wait a minute. Let me.
Just send me an email and I'll send you the Dropbox links to everything. And are you on the big list or not? No. I don't.
I'm on the talk shoe list.
Okay, right. You're not on our Rod class internal big list. Okay. All right. Send me an email at mentor2@gmail.com.
The number 2?
Yep, mentor2@gmail.com. And I'll send you all the links that you'll need, and I'll just send you a mirror of the big list. We're having a little problem with the big list. Our big list is an offshore server, and there seems to be some kind of temporary problem with it, and we don't know quite what's going on and what happened to our guy down there wherever he is. I don't even know what country he's in, but our email list is maintained offshore. And but anyway. So you send me an email, and I'll send you all of the stuff that you can go and look at Rod's stuff, okay?
All right. Well, I have a link on my homepage to Rod's stuff, and the link says...
Yeah, I don't know if it's the correct link, though. It's probably from years ago. Anyway, I'll send you the current place to find Rod's D.C. case and all of that kind of stuff, okay?
All right. Then I'll post it. So...
There you go.
Okay, very good.
Okay, thank you.
Okay, so, Rod, did you want to take some questions? Did you have anything else to say, or do you want me to just...
No, we can take some questions here, because I know people's got questions here, and once we get into this stuff, it's really not that hard to understand and go after this stuff. But, yeah, let's go ahead and take some questions. Let's sit down and see what we can do to help people.
Also, people are asking how to get on your chat board. I think I'm talking about his chat on his TalkShoe call. He's simultaneously doing a call on his call, AIB radio call. What's the call ID for your TalkShoe, Rod?
It's 48361.
48361.
Yeah.
Okay. And you're on Tuesdays and Fridays, is it, or?
Well, it's normally on Friday nights, but I've had to cut back with my wife here a little bit. But I do special calls, and when I do them, I'll let Harvey know, and he'll put them up on the big list when I do private calls.
That's assuming the big list is going to work. We don't know if it's going to work anymore. I'm getting nervous here. Anyway, yeah. But anyway, I don't know.
Okay, anybody that wants to ask a question, press *8, and that'll put you in the queue. You know what I wanted to say? I had an email list for Irwin Schiff, and it was huge. It was like 7,000. And I trusted somebody, and it went down, and that was it. It was gone. And I started to put everything on Yahoo. The Yahoo groups?
Right. I just don't have time to maintain a list like that. And that's why
you don't have to do anything. It's automatic. They go join. You put a link to it. The people join up. I've got one that's called Status is Freedom. All it is an announcement list. There's no emails going back and forth. It's just an announcement to let them know who's going to be on our call. And Yahoo seems to be working fine. And you can get into the thousands of members, and they aren't going to lose it.
Okay,
so I'm just telling you that it's something you might consider.
Okay, but I'm really getting old and up there, so I mean, I can barely just handle email.
Well, Okay, I'm just saying that's, if you're worried about your big list, if everybody joined up on a YouTube, I keep saying YouTube, and a Yahoo group.
I'll check it out, Anna.
Yahoo group, and then you don't have to do anything.
Okay. That sounds. I'll try and check it out and see if I can understand it.
All right. If not, I'll help you with it if you like.
Okay. That would probably be appreciated. I know it would be.
Thanks, Barbie. All right. Listen, we've got some folks in line that want to ask you questions. Everybody, please keep your questions concise and short and to the point. Don't take forever because we've already gone an hour and 47 minutes. So I don't know, how long did you want to go for, Rod?
Well, that's up to you with what we're doing. We got time, but, we don't want to go for another 2-3 hours.
All right. Okay. Oh, someone just got one. Well, let's see here. Patriot 1, did you have a question?
Can you hear me okay, Angela?
Yes, I can hear you fine. Hi.
Can you hear me, Rod? Patriot
Yep, I got you.
Hey, good to hear you, and you sound really good and up. It sounds good. I had a couple of questions. I'll stick to one. When I don't know if it was McFadden or the other senator that explained how a bill is signed and put through the discount window. Have you discovered any way that you or I or Angela can do that process to purchase anything, whether it be a car or a dozen eggs? Is there a process where any man or woman can do that, or do we have to do that through a bank, or do you know anything on that? And thank you very much.
Yeah. Again, it goes back in to where we're supposed to be able to file paperwork into the treasurer side. You got two parts. You got treasury and treasurer. I've done this with part of my paperwork in my case in D.C. Has it worked? I don't know, but all I know is that they did change my case number. They gave me another brand new case and started me over again on this. The problem we're running into is that none of these people are going to come openly and do this, because once we learn that doorway, there's going to be a floodgate. And what I did, is it wrong or right? From what I was told, it was right. But they're not going to allow us to come in, because it would now have to open up the Federal Reserve account and shows how much money's been embezzled, because we proved in my case under Title 31 CFR under Section 353 that deals with proceedings and judges' orders. So when a judge signs it, the prosecutor signs it, and the lawyer signs it, or public defender signs it, then under 363, it goes into the Treasury direct account. And they pull money out of our account, so we do know it exists. But can we get into it? I've never been able to get into it. Is there ways of getting into it? I've heard of this. And I think going through the Treasury is an avenue, because technically, under the bankruptcy of 33, the comptroller of currency is the receiver. The Federal Reserve, FDIC, is also the receiver, and so is the treasurer, which is on the left side of the dollar bill. They are the receiver. They're supposed to be discharging all this. That's how it's supposed to work. Are they actually doing it? We've tried it, and right now they ain't doing squat. We don't have enforcement. That's our problem with everything. We don't have enforcement. Go ahead.
All right. Okay, next up is Glenn Murphy. You've been unmuted. Go ahead. Did you have a question?
Yeah, Angela, this is Glenn Murphy. I know Rod. How you doing, Rod?
Hey, good, Glenn. How you doing?
Just fine. Angela, I don't know if you remember me or not. I was at Irwin Ship's trial.
Glenn. Oh, yeah. Hi.
I'm the one that confronted the judge. He didn't like it. Anyway, I had your number, and I lost. My phone went in the drink, and I lost your number. Now I don't want you to give it out over the phone here, but if I give you my email address, will you email that to me?
Well, sure.
Your phone number? Okay, it's
Wait a minute. Wait a minute.
Okay.
I gotta get a piece of paper. I'm not gonna. Let's see. Okay, what is it?
Okay, it's Trucker.
Trucker. TRUCKER.
Yeah. Dot. Glenn with one N.
GLEN.
Dot. Murphy.
MURPHY.
Yeah. At
At.
gmail.com.
Okay.
I'll be looking for it.
Okay, I'll email you. Did
Rod,
you have a question for Rod?
Yeah, I just want to tell him he can give me a call. I haven't been calling him because I know he's awful busy. But if you get a minute or two and you think about it, how about giving me a call?
Okay, no problem.
All righty.
Thank you.
That's all I got.
Okay, thank you. All righty, next up, wow, Glenn from a million years ago. That's amazing. Okay, Carl, be nice. I don't mean be a fool. Rod, have you ever met Carl Lentz?
No, but I've seen some of his paperwork. I've seen some of his recordings. Like I said, he's got good information. The problem is we're not dealing with a system that is honest. It's whatever they want to do at the time. Everybody's got the right answer. We just don't have the enforcement.
Okay, Carl, meet Rod. Rod, meet Carl.
Hey, Carl.
Hey, I've spoken to Rod a few times on his show.
Oh, okay. I didn't know.
Yeah, it was a very simple one when he had that blue light ticket. And he was talking about how many hours it took for the process to go through the court. And he was appealing it. And I just told him a very simple answer. I said, why don't you just go into the court and say that who is making a claim that this blue light is not OEM? I believe it is OEM. I believe this is the way I got the vehicle when I purchased it. So unless any man or woman is going to come forth and claim that this is not OEM, then it stands as OEM as true. And who would have came forth and said it was not the way it was originally manufactured from the original equipment from the manufacturer? Who could come before the court and say that that was not originally placed on that dashboard 10, 20, 30, 40 years ago?
Yeah,
Nobody.
Nobody. Yeah, that is a good argument, on what you're doing, and you're right.
And then this other simple one is, who was a plaintiff in this Washington, D.C. trial?
Well, see, I brought that up to the judge, and they told me it was the statute.
Okay, who was the name on the title, on the paperwork, in the caption?
It said the United States of America, and that's what I brought up. But we brought this up.
Did you bring up habeas corpus?
Yes, we did.
And what in the habeas corpus did you bring forth to the court?
Well, we brought in is the fact that if we could go back and show a constitutional violation or statutory violation that no injured party was part of this, they had to dismiss.
Okay, the Habeas Corpus Act simply states that any man who's taken into prison has the capacity, has the right to cross-examine his accuser that he's done something wrong. So why didn't you just bring a very simple habeas corpus, just write habeas corpus and say the number one rule in habeas corpus is that if I've done wrong, I have the right to stand and cross-examine my accuser. Who is my accuser or what is my accuser?
Well, see, I brought that up as numerous of documents, and Harvey and I,
I'm not saying it's numerous documents. It's one sentence. Just have to give a notice to the court or habeas corpus. Just ask them a simple question. Has habeas corpus been suspended in the United States? And they'll say no. It's like, okay, then under the Act of Habeas Corpus, do not have the right to have cross-examine my accuser. Who or what? I think it's more of a what that's accusing me of doing something wrong. Is it a who or is it a what? And do you understand what is standing before you? Do you think that I am a who or do you think I am a what? That's all you had to do.
Yeah, well, like I said, I did go before Kessler, I did ask who and where is who is the habeas corpus? Who is the injured party?
Not asked who's the injured party. The United States is an injured party. It's a harmed party. Only a man could be harmed. Injured parties could be my mailbox. My mailbox could be an injured party. Injury is something to a tangible object. Harm befalls man. Injury befalls the property of man. A personal injury means you hit my mailbox, you hit my car. If you bodily harm me, it means you injured my actual body itself. Harm and injury is not the same word. They're not interchangeable.
Well, the still comes back into the mailbox is not capable of writing out an affidavit and walking in.
It could represent. It could have a representative. I could represent my mailbox. I could represent your mailbox. I could represent the United States. I could represent the state of Alabama. I could represent anything. I could represent an apple. Am I the apple? No. But can I represent it? Yes. Can I act like an apple? Can I act for the apple? Yes, of course I can. Why? Because the apple has no capacity to stand, but I do. All you have to do is ask who or what is bringing this case forward.
Okay.
And am I not a man? Do I not have the right to cross-examine my accuser who's believe I've done wrong? And what wrong have I done? Have I done something wrong? And they'll say, no, you've done nothing wrong. I mean, that's exactly what they will tell you. You ask a judge a very simple question, have I done anything wrong? And he'll say, well, no, you violated a code, you violated a statute. Well, when I've done something wrong, you let me know. It's like, no, we're not here to discuss whether you did something wrong. And what are we here to talk about? That I did something right?
Yeah, like I said, your arguments. There's nothing wrong with your arguments. Your arguments are right on what you're coming in here with.
Oh, it's a lot of fun. I mean, it's very simple. I mean, you spent a lot of time studying statutes and codes, and yes, I did that as well. But one big thing I think that you should really be dedicating it to is reading, or well, not so much reading, but writing a dictionary. Because once you master the vocabulary, and once you master the words, there is no such thing as a synonym. In good law, the word is concise. The word only means one thing and one thing only. If it can have more than one meaning, you know this if you read code, if you read statutes. If a law is ambiguous, it is not a law. If it can be interpreted more than one way, it is not good law. It is not law at all. So when you say complaint and claim, it's not the same thing. When I say who or what is the plaintiff, it's not the same thing. Is it a who or is it a what? You have a who standing before you. Where's the who? I'm not a what. And who always trumps over what? Who, I, a man, will always trump over an apple or a mailbox, over a what. I could be harmed. It can only be injured. Big difference between a harm and injury. It's not a synonym. Huge difference. I can injure your mailbox. I can restore it. You can't harm me and restore me back to where it was before you harmed me. Huge difference. You have to know these words, and you have to be concise, and you slice through it like a razor. Once you make the words so sharp and so crisp, you need so few of them to use. Like the judge said over in England to some man who called me up. The judge said, if you really want to use this common law, sir, you better keep it down to one-syllable words. If you really want to master this, you better get it down to one syllable. You better make it short, sweet, concise, right to the point. So I'm just trying to give you a little hint there to try to stay away from two-syllable words. If you can make it one syllable, use the one-syllable word.
Okay.
And that's a good way to go at it. I mean, if you want to ask me something, you can if you want to, but
no, like I said, I understand. You've got some good information out here, and there's nothing wrong with your information because I've listened to it. My intent when I got into this D.C. case, like I said, I wasn't walking in here as a defendant. I was walking in here as a prosecutor. I was in there to expose their corruption. And that's something that majority of people out here aren't doing. Like you said, you're saying who or what. I'm walking in here and saying, your rule says you can't do this. Number one, under Rule 3 and 4 and 5, you had to have a complaint. You had to have an affidavit. You had to have somebody that was injured, and you can't write it up after the fact. You had to have it before the fact. And that was...
Yeah, but an injury befalls a what? An injury doesn't befall a who. And you said it again. They had to have an injured party. That's a what? It's easy to have an injured party. Anything can be injured. You could injure my apple. You can injure my mailbox. And the big thing, too, is when you were saying, That you came in as a prosecutor. So that meant, like what's his name? The guy with the long beard, the man out of California explains. I don't know if his name is, I forgot what his name is. But anyway, when you come in as a prosecutor, then you have to file your own case before the court. You have to be the plaintiff. A prosecutor is the plaintiff. The prosecutor is the one pursuing the defendant. So if you didn't come in with your own claim or your own complaint into court, you can't be the prosecutor. You said you wanted to prosecute them, which is fine. Did you file a case at the same time that they were moving their case against you in that same public courthouse?
Not the same day, but I did go back in and bring in a claim against them. And I did sit here and make the issue. But the point I was getting into with these people, that any time the prosecutor said anything, I was able to come back in and object, and I was able to sit here and show what he did wrong, where he did it wrong, and how, especially when the judge was questioning me on some of this stuff. I was pointing out their errors. Before you sit here and talk to me, you better get your own act straight.
But you said early in the show, 15 years ago, the very first lady judge back in a little town of Ohio said that you cannot use their stuff.
Yeah.
And if you do choose to use their stuff, that there's a hierarchy system, like the United States Supreme Court makes the ultimate decisions for them. There's a pyramid scheme, and the judge sits way above the defendant, and you're just a defendant. So when you're coming into court with their stuff, she's saying you can't use our stuff. First of all, you got to get permission to use this because this is copyrighted and it's privileged access information.
Right.
So, and if you do try to use it, you know what? I'm just going to deny you because you know what? I'm the daddy of this court, and you're just one of the children. I run this court. So why bring their stuff into their court? Why not bring your own stuff?
Well, at that particular time, this goes back 15 years ago, and a lot of the stuff that you're teaching and what Howard Griswold taught was not out here on the Internet accessible at that time.
Okay, all I was just basically saying is the lady told you 15 years ago not to use their stuff. That was very good advice she was giving you. Now you came, into this district court, the D.C. court, and you're still using their stuff. Somewhere along the line you should have said, you know what, their stuff is not going to work for so I better try a new tact because their stuff is useless for me to use. So you know what?
The thing of it is, you're saying it's absolutely useless. But it's not, because by me coming back in and hammering the shit out of them and doing what I did with them was not what they were expecting. They expect the typical person coming in is that I'm not that person, and that's my whole argument. Well, my argument was when the judge sits here and says, we brought up about the word person, I proceeded to explain to her their terminology, and that didn't fit me. I'm not a person under your legal definition. I didn't have a firearm under your legal definition. You're sitting down and mixing and matching your words, and this is where the issue's coming in. I'm coming back in and showing them what they're doing wrong, how they're doing it wrong, because they're using words in such a general terminology that if we don't come back in and rebut that general terminology, that's why we're getting our asses handed to us.
Did you tell them that you were not a legal person?
Yes, I did. By my paperwork, I came back in.
Do you understand that every single other entity that you saw in that courtroom was a legal person? It was a judge, it was a bailiff, it was a clerk. You understand they were all legal persons. And so when you're saying you're not a legal person, well, what you're doing is you're saying, okay, I'm not in this game. Everybody else in this room is in this game. I choose to opt out. I'm not a legal person. So if you're opting out of being a legal person, what's going on is a legal procedure with legal person speaking. They're not going to hear you because you just said I'm not a legal person. So you're opting out. You're taking the status of that of a man or whatever. You're pulling yourself out of their game. Only a legal person has status and standing in a legal procedure. Once you said you're no longer a legal person, you no longer have status or statute. All your paperwork is going to be falling on deaf ears because you refuse to be a legal person.
But again, you and I could go for hours on this, on your way. And like I said, your way's not wrong.
It's not my way. It's just the rules of the game. If you want to opt out, if you don't want to be a Boy Scout in the Boy Scout society, if you don't want to be part of the legal society, if you want to opt out, you're voluntarily, nobody could force you to be a Boy Scout. Nobody could force you to be a legal person. You chose to opt out of being a legal person. Once you jumped out and said, I don't want to be a legal person, I am not a legal person, well, then it's like, I'm not a Boy Scout. Okay, we're having a Boy Scout jamboree. You're not going to be part of this. Okay. Anything you got to say, you know what, we really don't care.
Again, it goes back into, I have watched firsthand where people have tried to do this, and by remaining silent, coming back in, and the judge just bangs the gavel, and they get their ass hauled away anyhow, and you can yell and scream all you want, is that I'm not in here, I'm not legal, I'm not here debating. Like I said, we're not dealing with a legitimate system right down the line. What you're saying is not wrong. Well, a lot of people have come in here, they're not wrong. But what I went back in and went after was to show they're not following anything. They're not following anything. And that
like I said, I've just been very lucky in court, and I put the paperwork in, and I tell people don't open their mouth. Always put it in writing. And when I was put on trial in Canada, the judge asked the prosecutor and asked the investigators, what is the most inflammatory thing that Carl tells people on his shows? And they said, Carl always tells people, do not open your mouth in court. Make sure it's in writing first. Once it's in writing, then you can record it. Then you can put it on the record. But make sure that everything that you say to that court is put in writing. That way it has to be filed. And that way, once you utter it, it's recorded. So when you just start yelling out things in court, like you said, people walk into a court and say, I'm not a legal person. Did you put it in writing? Like, you got the ticket 30 days ago. On 29 days ago, did you put it in writing that I believe you issued the citation to a legal person in which I am not? No, you didn't do that. You wait until the day of the trial, and then you think you're going to walk in, just like with you. You had preliminary hearings. You could have set the rules at the time of the preliminary hearing that the plaintiff will appear, that you will abide by the Constitution. You can't do it during a trial. You had the time for it at the preliminary hearings. And if you choose to wait until the actual game day, when the battle is in the heat of battle, you're not going to be able to enforce any new rules. They had preliminary hearings where you could have contested their procedures.
I did.
And if you failed to, okay, well then you say, I can only appear under these conditions. I guarantee there's nothing in writing that says that you cannot appear as a defendant to be an active member of this legal procedure unless we abide by these rules. And then you got a ruling that, no, we are not going to proceed under the constitutional rules, and you'll have the judge put it in writing, say, we are not going to proceed under the Magna Carta, we are not going to proceed under a court of record, we are going to proceed in this manner. And in that way, you'll have proof for everybody of all time that it's corrupt. But until you have a preliminary hearing and you get rulings by the judge, you'll never be able to prove it's corrupt, except that you failed to bring into the police that you will only appear under these conditions, like you want blue M&Ms at every concert that you're going to appear at. And they're going to say, no, we're not going to have blue M&Ms. You're going to appear regardless. You're going to have to bring something in writing at preliminary hearing saying that you're establishing the rules. These are the procedures in which I will appear. If you fail to abide by these civil procedures or these criminal procedures that have been well established for the last 500 years, then I cannot appear at this time. I will not be able to appear in this manner.
Okay, but I have done exactly. Put the paperwork in. The paperwork went into the mail office at the federal court, went straight into the judge's chamber. The judge wrote across the top, denied, failure to file for leave, judge's name, dated it, sent it down to the clerk of court. And like I said, it got down there about 2 weeks later. The judge never cut an order. I have filed paperwork in. I have went back in and I nailed the prosecutor because they have not answered the paperwork. Judge Kessler told told Lawless, do not answer this man's paperwork at any memorandum whatsoever.
Okay, so when the judge denied you, what did you do next?
I went back in, filed more paperwork in, making an issue under Rule 12, that under Rule 12, you cannot deny any documentation that can affect my appeal. You are in violation of your own rules and regulations.
Is there some reason why you didn't just ask them to give you the findings and facts and conclusions of law? Did you not just ask them, get point of law? How many times in the trial did you yell out point of law?
Well, I've never had a trial. Everything that I've had from May 30th, 2013, up until February 9th was all status hearings. I never once had a hearing.
Okay, so anytime you never came before any magistrate or a judge?
Yes, but they were not trial. They were nothing more than
I didn't say that. I didn't say they were. Okay, they were whatever you want to call them, adjudicatory hearings. Maybe they were adjudicatory hearings. But if that's what they were, is there any time that you had an issue with what they were saying? Did you just yell out point of law?
Did I
use? Can you give me a ruling on on how you came up with that crazy? Why are we proceeding under this way? That's all I'm saying. Did you just yell out point of law?
No, I never.
Can you give me a ruling?
No, I never once screamed point of law.
That's what I'm trying to say. Instead of you trying to correct them, why did you let them try to correct themselves? Why don't you say to them, hey, excuse me, point of law, and let them explain it, instead of you saying, well, the Constitution says this, and the statutes say this, and all these articles of Confederation say this. Why don't you let him say where he's getting it from? Why don't you let him tell you, so you can say, okay, thank you. Is that where you're getting it from? Let me do some research and see if you're on top of your game. Okay, thank you. So you keep telling them what they should be doing. Why don't you let them tell you why they're doing what they're doing instead of you telling them how they should be doing it?
I'm not going to argue with you. I'm not going to debate with you. What you're saying is correct. I'm not arguing with that point. But I'm also...
It just makes life easy.
But there are different avenues because I have watched so many people try to walk in and defend, and I don't defend. It's not my job to defend. It's my job to point out their screw-ups.
Okay, so that's what I'm just trying to say. You're trying to point out what they're doing wrong. Why don't you just ask them? I believe what you're doing is wrong. Can you give me a point of law on which you're relying on and how we're moving or not moving in this manner? So instead of you telling them you're doing it wrong, why don't you say, I believe you might be doing it wrong. I'm not sure. I'm not an expert. I'm not a lawyer. I'm not an attorney. I think I'm pretty good at this. But you know what? Can you give me the point of law on which you're relying upon? Because honestly, I think you should be doing it this way. But honestly, why are you doing it this way? Is there some law that you're relying upon that I'm not aware of? That's all I'm saying. I'm just saying acting more courteous or more cordial when you get to the court. Just play stupid. Just play like you're dumb, like you're an idiot. But they know you're not an idiot because you kind of know what you're doing. So let them fill in the blanks. You give them the questions. You ask like a king. You give the questions, and you let them do the answering. Instead of you spouting out, let them spout out. Because then they can be held liable.
Well, they have, because like I said, whenever Judge Roberts, we got into this thing, and I brought up, because the prosecutor brought up that Mr. Class, he came into D.C., he did have in his ready-to-carry and ready possession his firearms. I said, excuse me, I object. I said, first off, your judge just ruled what he sit down and said was unconstitutional. And what did Judge Roberts say? Oh, well, we're going to try to get that overturned, so we're not going to allow that argument.
Why don't you just say to him, I have no idea what the term or the word firearm is, but what I do know is that everything in that car, everything outside in that driveway, everything outside in that street is my property, and everything within that property is my property, and nobody has any right to tell him what I can and cannot possess. That is my property. It is not stolen. Nobody's got a complaint or a claim that that this piece of property has been stolen. That's 6 inches long and 3 inches round. So is somebody making a claim that there's some stolen property? Because other than that, that's my property that's sitting out in that street. I am not in Washington D.C. I'm standing on the North American continent, but I am not in Washington D.C. It's like I tell everybody all the time. It's like, do you want to meet me in that rock or do you want to meet me at that rock? I am not inside of anything. What makes you think I am in Washington, D.C.? What is a Washington, D.C., and how did I fit inside of it? How big is this Washington, D.C. that you speak of? What is a Washington, D.C.? Please clarify.
See, Carl, I've never learned to play those kind of head games. And that's exactly what it is. That is a head game. And I was never taught to play those kind of head games.
It's a word game. It says crosswords. I'm crossing words with you. And that's what they're playing. They're word nerds. These people on the bench are word nerds. They live for words. They've been doing it since they were little children. They're word nerds. So you're crossing words. Instead of crossing swords, you're crossing words. This is the battle that you're in. You better know the battle that you're in. You better bring the right tools. You better bring the right equipment because they're crossing words with you. They're concise. They don't have synonyms. Everything means one particular thing. And unless you want to get concise and precise with these people, they're going to slice you up.
You know what? We have Akila is in online, and she's waiting with her hand up. And can we move on?
All right. Have a good night, man. It was good talking to you.
Thanks, Carl.
All right. I was being nice now, right?
You were very respectful. I appreciate that. Thank you.
Okay. All righty. Have a good night.
Thank you. You too.
Good night, Carl.
All right, Akila, you've been unmuted.
Hey, everybody, I was just listening. I just, came in on the end.
Oh,
it
did you
sounds
have a
good
question?
what Carl was saying. No, just wanted to say hello to everybody. And, I put some paperwork Carl had helped me out with and a couple of others. And I got a response back. I was dealing with my health, Angela. I told you about 6 months back. Well, they want to sell. They said they want to sell out of court now.
Oh, is that what you want?
Good. Well, I just want to be compensated for the time and labor I put in this project, and that's the only way that it's going to get, resolved.
Very good, and you succeeded.
Well, so far, yes. It's because, I listen to a lot of Carl stuff and his way of action, and he helped me out, with a lot, even on your show with a lot of his older tapes. And I was listening to that, and and it really helped me,
Well, that's wonderful.
And how you doing, Rod? Dale Flash, right?
Oh, yeah. Yep, we're doing good. How are you?
I'm good. Just wanted to say hello to you as well. And I'll continue to listen, I guess.
All right.
So if anyone have a question, that would be great. All right, Angela, thanks a million.
Well, thank you. Let's see, Trustor on here is asking, could Rod go into detail on his case where a guy who had a $500,000 mortgage looked up his SEC filings and saw that it was valued at $93 million. Really?
Yeah. What we was doing, we was getting into the financial side of selling your signature. We had a forensic auditor that worked for the Security Exchange Commission. And we started explaining some of this stuff to him, and at first he thought we were sort of crazy. Well, they went after him for foreclosure. He went back in because he worked for the Security Exchange Commission. He went back into and got into his file where he bought his home originally for $500,000. He started tracing it where they sold his signature. That's what they were selling. They were selling the notes, but it was his signature. And as he went through, by the time it got through the last bank, they sold his signature for $93 million. That's what they're getting off of our name. That's what they're getting off of our signatures.
Yeah.
And he walked into court, and he brought in 16 boxes that you would go down to Staples, like you'd get for paper reams.
Mm-hmm.
And he proceeded to lay them out before the judge. And he says, by the way, you realize these people never paid taxes on any of this money when they sold this mortgage. Because if you buy a home, you got to pay taxes on it. And every time they sold that note and sold that mortgage, they never paid the taxes to the county on it. And he proved that your signature was worth $93 million on that $500,000 home. And once he started understanding this, he started going back in and started checking. And this is why they're dragging our asses into court. We can play all these word games. we can play, who's who, what's what does if mean, what does not mean. We can play all this. If the judge wants to let you off, they will. But the main goal is they want your signature. They're getting into your account. That's why we're having such a problem out here. This is one of the reasons why I did it the way that I did it. I went after them. I wanted to prove absolute corruption on their side of the fence. I didn't want to sit down and play, it depends on what if means, or what it means, or what on means. My job was to walk in, the moment the prosecutor said anything and the judge questioned me, then I went back and laid out what that prosecutor did wrong and how he did it wrong. I showed procedural errors on their side of the fence. This is not for everybody to turn around and do. Everybody's got a different avenue to go run with. Like I said, Carl, with what he's doing, he isn't wrong with the way he's coming in. He's not wrong at all. But on the other hand, I didn't go to jail either. And there's a lot of guys that's sitting in jail.
Oh, I thought you did go to jail.
I went to jail for contempt charges because I didn't show up for a hearing. But the problem of it is I was supposed to show up on October 27th. On October 23rd, they dropped my charges and brought a brand new indictment against me under a brand new case number. So when I was in there on that 21st with the judge for my brand new arraignment, because the other charges were dropped, he sat down and said, you have the right to remain silent. You have the right to an attorney. You have the right to file. I said, whoa, wait a minute. Are you telling me that this is a brand new case? He says, yes. This is a brand new case. They dropped the other case. I went to jail to teach me a lesson. And it didn't work. They didn't teach me anything. All they did was piss me off.
Yeah.
But like I said, I didn't go to jail for the gun charge. They nailed me for contempt, but the charges were dismissed. They brought a brand new indictment against me. That's what I'm sitting here saying. With what I'm doing and how I'm doing it, nobody's ever has been able to walk in and slam the snot out of these people. Most people want to play word games, and there's nothing wrong with that. It depends on what is. I don't play that. I've never got into playing it.
Yeah. Well, but it is a word game. You've got to admit that.
Well, yeah, it is. But what I've learned in the administrative side, when I've walked in and I started hammering them, the first thing the administrative court did was throw these people under the bus. They went back and said, oh, they don't work here. They don't work here. And the reason why, when I started bringing in the Highway Safety Act, and I started bringing in the federal funding into my political subdivision, had they come back and said, well, Mr. Class, boy, you sure are right. These people are public officials. They are law enforcement. They would have to cough up federal funding as far back as 1967, and they would have to pay the political subdivision all that federal funding back. It was much easier to sit down and say they don't work here so they can embezzle the federal funding. There's two ways of playing this. There's two ways of coming in, and it's strategy. What you are playing word games with these people. It is a mind game. Mm-hmm. But it's also coming in and showing that I know their rules, I know their regulations, I know how they're supposed to operate. And this is why the public defender said, Rod, damn it, you know too much. You need to keep your mouth shut. You're talking too much. You know too much. Well, that's exactly why I'm in here. I'm showing you that you're wrong, because when I started laying this stuff out, but it's like he said here and said, we aren't taught law. We're taught theories, and we're taught concept. And that's one of the things that I nailed Roberts on February 9th. Because when the prosecutor put in his order, he said, I now hope that Mr. Class will learn to follow the law the way it is written and not the way he wants it. And I asked the judge, I said, whoa, let me explain something to you. I said, did I not have a carry concealed permit? Yes, I did. Was my pistol and rifle registered? Yes, it was. Did you people have your property posted that says you can't bring this stuff on federal property? No, you did not. So would you like to tell me what laws I didn't follow? And I said, that's right, I forgot, because you told me on November 21st, you guys don't run law. You run theory and concept in here. So could you tell me what your theory and concept's going to be for today and what the future rulings of theories and concepts going to be in the future so I can get a book on them? And the judge just dropped his head and shook his head. So even if you want to play the word game, you're still playing with theories and concept on their side of this fence to where...
Well, yeah, you're in their court. You're on their playing field.
But no, everybody has their own way of coming in, and nobody's wrong on this. It's just that I went the long way around to prove absolute corruption on their side of the fence. Like I said, I didn't defend myself. I went after them. And granted, yeah, Carl's way is shorter. It's easy to come in and say, who was injured? Who's the corpus delicti? You know, if the judge wants to sit down and answer that, then he can. And if they don't, then what do? You know, you got to have the next answer for whatever they decide they don't want to play. You got to have the next answer.
Never ending.
So.
But you know what? We've gone 2.5 hours.
Okay. Sounds good.
There's no one else has their hand up. And I appreciate your time, and I hope you'll come on again and give us an update and let us know how things are going. When are you supposed to go to court again?
I'm not. I'm waiting for the appeals court to make a decision on my court case. And
so as soon as you find out, you'll let everybody know, right?
Right. You know, and this is the whole thing is because, like I said, D.C. is forced by Judge Scully and by Thomas Massey. They are forced into changing their gun laws. They don't have a choice. And what the kicker of this is, Angela, is this. Is when they did the Heller case in 2008, and in the Heller case, the Supreme Court ruled that the D.C. gun laws were unconstitutional. That means that anybody who ever had a gun issue in D.C. prior to 2008 now has a claim against D.C. because the Heller case was ruled unconstitutional for them to do what they did. And now with this Tom Palmer case with Judge Scully supporting that, this is really got to put them in a bad hurt because now people can go back in and sue the shit out of them and hammer their ass.
Okay.
And that's where we're sitting at.
Yeah, but the problem is when you go to sue them, you got to sue them in their own courts and their own buddies, the guys that are going to make the opinions, give their determination, right?
Well, you do, but what we're doing, and no, it's again, you have to strip them of their immunity. You have to go in and get them to throw them under the bus, and that's what we've done. I haven't had the opportunity at this time to follow up.
Even if you did strip them of their immunity, okay, and you went after them in their own, private capacity or personal capacity, however you want to say it, doesn't one of their crony judges have to hear whatever your case is going to be that you're suing them at?
Well, yes, they are, but you know what? If we don't start, we're never going to have anything. We have to make the effort. That's where it comes to the people. The people are going to have to start coming forward and doing this. This is one of the reasons why we're getting into the International Tribunal of Natural Justice, which is going to be the People's Court. This is why here in June 27th to July 4th, we're going to start a PAG school down there in Arkansas for a week where we're going to teach people to do administrative procedures. Don't wait for them to come knock on your door. We need to be knocking on theirs, and we need to be hammering them right off the bat. Don't wait for them to come to you. We need to start suing them. And it's like Cornforth stood here and said, back during Prohibition, 80,000 people changed Prohibition. 80,000 people out of this country back in the 1920s. Here, during the Iraq War, a congressman out of Illinois or Indiana made a comment about our military troop, and he said, I will never apologize. 135,000 emails to his email. He was on C-SPAN apologizing to the public for his comment. Madam O'Hara, one single woman back in the 60s and 70s, says, I don't want religion in school for my son. And guess what she got done? She took the religion out. One woman.
She was a spokesperson, I think, for the powers that be, right? That was the agenda.
But it was her case that overturned our system. And that's what I'm sitting here saying. It's going to take us to come in and to go after them. But we have to know their rules, their job. And if I'm going to make an issue, I better know what their job is and how they're supposed to operate. I can't make wild claims and accusations.
Do you know Paul Andrew Mitchell?
Yep. I haven't talked to him, but I know of him.
He's been on our call a couple of times. He says a lot of the same things you say. He's also a private attorney general and has, puts paperwork into the courts doing basically the same thing you're doing. And I don't know. I don't see any end to it, and there's no relief yet. I don't know.
As long as we're going to play single words and we don't try to fix the problem, as long as we're going to play word games of is and who, and that's all we're going to do, that's not going to fix the problem.
Yeah, I don't think that was what Carl was saying. I think you missed the point a little bit on that. It's not a matter of playing word games. It's about how you present yourself as a man or a woman, and don't fall into their trap words, and their statutes and codes and regulations. If you're a man, you stand as a man, you use your own words, and don't fall into that trap that they get everybody into.
Okay, but how do you go back and fix that problem if you don't go back in and show where they did anything wrong other than you don't want to fall into that trap?
Well, you're right. You can't fix it because it's an individual. Every individual has to deal with it that way when they go in, and that's not going to happen anytime soon. But I don't think you're going to fix it or change it. Like I said, they're not going to cut their own throats. But I know what you're saying is you can't give up. You want to keep going. You want to be successful. That's what happened to Irwin Schiff, though. He was right in everything he said about the IRS, and he just. Okay. But they ran over him in the courtroom and just got him out of the limelight. They wanted him not teaching people what he knew.
But stop and think here a minute. Here, about 7 years ago, think about the banking system, how it was, and then now you think about how people started exposing them selling the signatures. They're securitizing. What has happened to the banking system in the last couple of years since this has been exposed by the people? What's it done to the banking system?
I don't know what.
Well, how many banks are now being sued and have to pay money back on what is going on? And look at the amount of bankers and stuff, what is being reported, and I haven't had that they're committing suicide and then losing their jobs over this stuff. But 10 years ago, you never heard about this. And now, with what has happened in D.C. within this last year, it is now, like I said, on was it December 14th, something like that, in 2014, the Sixth Circuit Court ruled that a gentleman that was in a mental institution because he had some type of breakdown, he got a clean bill of health. He tried to get one, and the state would not allow him. He sued, and the court writ back on the Heller case and the McDonald case and sat here and said, this man's got a clean bill of health. You cannot deny him. He is entitled to have something for protection. And that's the same thing out there in California with the Ninth Circuit Court. There was a gentleman that was out there carrying, from what I remember, they wanted him to have a carry permit, and the Ninth Circuit Court says no, he doesn't have to have a permit if he's got it out in the open. And they referred back to the Heller case and the McDonald case, and this is what Judge Scully is doing. We're starting to see gun laws changed across this country. And how much of it had to do with the paperwork that I put in, I don't know for sure. But their basis and their foundation of changing it is because of what I put in. My paperwork is the part of the foundation of why they're coming back in saying they have to change their gun laws. So it takes time for this stuff to do. But if we're going to come in and do it on the individual side, that we're just trying to get ourselves out, there's nothing wrong with that. And if that's what people can do, by all means, go do it. I, on the other hand, am want to come after these people, and I want to bring claims against them. I want to bring administrative claims against them. I want to start stripping them of their immunity to get their side to throw them under the bus. And when we went to the Sergeant of Arms of the House and Senate, and we went to the United States Administrative Court with the SF-95 forms and our claim for tort, the first thing these did within 2 weeks, we got a letter back saying, we've investigated. If you don't like our decision, you now can go sue them in their private capacity under Title 28, 2401, under a federal tort claim. You now can sue them. And they lose their immunity. So we're getting this kind of paperwork where they're being thrown under the bus. But it's something that we need to work on.
Yeah.
Nobody really has the right answer because there is no 100% guarantee on what anybody is doing, because somebody else could walk in and run with all these other documents, and they may not always work. Because I've watched people use Jack and Mary Flynn stuff, and they didn't always win. Jack and Mary Flynn won, but other people didn't win. Now, did they use the very precise, exact wording when they went in and they talked? Did they sit down and say the right magical words so they wasn't mixing their words? Who tells? But we shouldn't have to play these kind of games. That's the point.
Yeah.
We should.
But as long as there's a bar association, they're going to make it as complex as possible. They're not going to teach it to us in the schools. They're not going to advertise it on the TV or the radio. They're going to keep their little practice, their little religion to themselves and use it to their advantage.
Yeah.
It's the way it's been for a long time. I don't see it changing anytime soon.
Well, see,
but I mean, you look at the people out there. There's a lot of stupid people. They've dumbed them down so badly. It's pathetic. You know,
It is, and the thing is, we should not have to sit here and try to guess what words we need to choose or how we have to say it. The bottom line is, did you, under your rules, have a proper complaint with an affidavit and a warrant issued by a judge before you pulled me over for this traffic stop? That's the point here. Did you have a complaint and a warrant and a affidavit when you pulled me over for this traffic stop? Did you have this readily accessible where someone turned me in before you showed up here, before I got to this stop sign to charge me? No, you did not. What does your rule say? Your rule says you have to have this. That's the point. They're not following. They're not doing. There's never an injured party.
I know.
And the state is only claiming the injury because they now can get into your account that was set up for them to embezzle and swindle off of you. But it's not coming back into the political subdivision. It's going into their retirement system.
Yeah. Such a conflict of interest. It's ridiculous.
Yeah. Like I said, you're right. This is not supposed to be rocket science. You and I ought to be able to walk in, and there should be a truly injured party here. Somebody had to be hurt. Not a fiction, not some statute, not some robot out here, not some straw man. There actually had to be, and before they started all this stuff, there really, truly had to be an injured party in that courtroom. And they're not doing any of this because there's too much money on us. Like I said, we went back and showed through the Social Security Act that the state gets $1 million each fiscal year for each live birth. I'm 60 years old. They're sitting on over $60 million. And that doesn't include what I did for working and what they got off my labor for working. I had a gentleman that ran a company, and he went back in and he had over $18 million in his birth certificate account. And when they went back and brought him into court for foreclosure, it showed where they took $1 million out of his birth certificate account to pay off the loan.
Yep, they aren't going to let us have access to that account. They want to be in control of it. They let the banks have the upper hand as far as that Fed window goes. So when you sign a mortgage, they send it to the Fed window. The Fed window sends them the money.
Yeah.
Or the Federal Reserve notes, I should say.
Well, this is why, like I said, but if you're not going to go in to any of these court cases, and you're not going to make those issues, because they're not going to sit here and allow it, because when I dealt with the tax department here in North Carolina in the administrative court, and I filed a claim against the tax department bringing up the 1913 Federal Reserve Act and Title 12, 411, and Title 18, Section 8, and we brought all this stuff up. When we went before the administrative law judge, the Attorney General sat here and said, Your Honor, I don't know what Mr. Klaus is talking about. He's bringing something up about the 1913 Federal Reserve Act. He's bringing up something about the 1933 bankruptcy. I don't have a clue what he's talking about. And he went on and on and on. And I told the judge, I'm going to object to all this. So when I had a chance to talk, I looked at the Attorney General assistant. I said, I pulled out two $5 bills. I said, sir, obviously, seeing how you don't know what the Federal Reserve Act is all about, would you please tell me on the record what these two items are that I have in my hand? And the judge immediately says, you do not answer him. You keep your mouth shut. I looked at the judge and said, excuse me, he's telling me he doesn't know what the Federal Reserve Act is. Here is the Federal Reserve Act of the result. I want him to tell me what these are. He said, he's not going to answer that. I looked at the judge and said, then you tell me what it is. He just dropped his head and shook his head. I said, now, you want me to pay taxes, but you can't tell me what these two items are. Would you like to tell me how I'm supposed to pay taxes when you can't even tell me what these are? And the judge just ruled, these are private individuals. This case is dismissed. They don't work. They're not part of the state, and this administrative court don't have jurisdiction. This is where the issue's coming in. This is the difference, Angela, with what I do and how I do it compared to a lot of these other people. I go after them on this stuff. And until we get knowledgeable enough, until we get gutsy enough to start coming back in and nailing them with their own legislative acts of defining things and their own legislative records, of congressional records, Because McFadden sat here and explained in 1933. He sat down and talked about a Scottish distiller selling.
I had it posted on my website. That section of McFadden's speech. Yeah.
So he sat here and proved it is your signature that sits here and pays all the bills. It isn't the Federal Reserve. It isn't the property. It is your signature that clears the debt. The problem of it is the system is taking your signature and they are selling it out on the market, and they're not discharging the debt, and they're coming back in and hammering you under that all-capital name, that birth name, and holding you responsible for their embezzlement. So until we start going after them and start bringing this stuff up of how they are embezzling, the system is never going to get fixed. Now, from what I'm understanding about what Karen Hudis is doing, now, she is going after the global reset. She's trying to go after some of this stuff, and she's got another avenue, right, wrong, or indifferent. I'm not going to sit here and pass judgment, but she's got another avenue that she wants to try to work on and go after. And I hope it works. We're trying on the international side for the International Tribunal for Natural Justice of getting it up and running, getting it seated, so we can come back in and hammer our own system on its own grounds. Because what has happened with these international courts, they can make a claim against the United States as long as they stay 7 miles off the shoreline or at the borders and they don't enter this country. And if the United States don't like the rulings, they just tell them to kiss off and walk out of the courtroom. And you can't touch us because we got immunity. We're trying to get this thing set up to where the ITNJ can walk into this country. And one of the things that they found out by listening to me and going through my documentation is that when we brought up the International Organization Immunities Act, where all these public offices belong to the UN, that makes this international. This now allows the International Court to hold and try these people under international law. They're not Americans. They relinquished their citizenship. And one of the things that I brought up is this War Powers Act that allows Obama to walk into any foreign country at any given time and set troops on the land. That's a two-way street. If we can send troops over to invade, then these people can bring the international court into here and charge Obama and these people for war crimes, as well as the judges for crimes against humanity and involuntary servitude and slavery. Because that is a UN violation. War crimes and human slavery is a violation of international law. And the courts are doing it every single day. And we're trying to get this set up so we can start doing accountability on them. There's a lot going on here. Like I said, does anybody have the right answer? Is everybody wrong? No. Everybody's trying the best they have to work with what they have.
Right. That's it. That's all we can do, right?
That's it. That's all.
Hope that the masses wake up a little bit.
Yep. Okay, honey. Well, it's going on 12 o'clock. So if you want to cut this off, we can.
All right. Yeah, we've been at it almost 3 hours, so that's good. I think this call is going to be downloaded a gazillion times. It's a really good call. I appreciate your time and coming on, and I hope you'll come on again and update us in the not-too-distant future.
Well, I've been trying to get back with everything that I have got going here with my wife having the health problems that she has got going. This court case has really, really stressed her body out and has really sit down and caused her a lot of medical problems.
Oh, I'm sorry to hear that. That
we have to deal with, and it has stressed my system out with what we're doing, but I'm keeping a good sense of humor because I want to play games with these idiots.
Well, you keep up the good work, Rod, and I love you, and we'll talk again soon, and take care, and I'll say a prayer for your wife.
All right, thanks, Angela. You guys have a good night. Thank you.
Thank you. You too. Bye-bye.
Bye-bye.
Call recording has been completed.